Welcome, folks. It is September 2nd. It is 9 a.m. and we are allowing our participants to join us. This is day 8 of the Colorado Oil and Gas Conservation Commission rulemaking around mission change. We will give everybody another minute or so to join us, and then we'll get started.
Good morning. I'm working from the City Park Annex for a little bit, but I should be in the office later.
Good morning, Director Murphy. Good to have you with us.
Thanks.
All right. It looks like we have the majority of our participant stakeholders with us this morning. Welcome, everyone, again to day 8 of the COGCC rulemaking. We will start with roll call by Hearings Officer Larson.
Thank you, Mr. Chair. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam. Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Great, thank you. And I believe that we will have Commissioner Putnam with us in about 30 minutes or so, which is fine and appropriate. Again, we are deep in the midst of rulemaking here at the Colorado Oil and Gas Conservation Commission. We are in the middle of witness testimony on the 400 series, which is the sort of operational series of rules. We took evidence and testimony yesterday from witnesses. We're going to do that again today. I believe we're set to take evidence and testimony through, say, midday. And if all things go well, then we would close evidence and testimony on the 400 series, turn to staff closing, party closings, and then commissioner deliberations. With that, Ms. Larson, I believe we need to zoom to the forefront our first panel, which I believe is Battlement Concerned Citizens, Conservation Colorado, Western Colorado Alliance, and Grand Valley Citizens Alliance.
That is correct. One moment while we get that panel in.
You do your magic wand and bring them to the fore. Good morning, Mr. Sura. Are you the only participant with this panel, or do you have friends that will be joining you?
There is going to be co-counsel Matt Samuelson and witness Benjamin Blair will be joining us as well.
Okay, let's go find those guys. Good morning, Mr. Blair. Glad to have you join us.
Hi there.
Just want to make sure when we hear that Matt Samuelson has joined us as well, I'd like to share my screen. It's not allowing me to do so at this point.
Ms. Larson, you're muted.
Thank you. Give me one moment, Mr. Sura, and we will make sure that you're able to share your screen.
Thank you.
Mr. Sura, you should be able to share your screen now.
Did it. Great. And has Matt Samuelson joined us?
Yes, he is.
Yes.
Well,
Oh,
Great, wonderful. Well, then I'll begin if that's all right.
Go ahead, Mr. Sura.
Thank you. Good morning, commissioners. This morning we plan to address 3 issues: noise, public water supply protections, and meter calibration. But first, I want to address nuisance. Throughout this rulemaking, you have heard from dozens of people about how oil and gas development impacts their health and welfare. Describing odors and noise as nuisances diminishes the importance of addressing these issues. Even as a nuisance, odor and noise are clearly a public welfare issue and must be addressed pursuant to Senate Bill 181. But odor and noise are much more than nuisance issues. They are impacting public health. I encourage you to download the entire Colorado Oil and Gas Conservation Commission complaint file. Noise and odor complaints are being registered by Coloradans hundreds of times a year. We looked at the complaint file from August 2015 to August 2020. In the last 5 years, there were more than 3,600 complaints. Over 1,000 complaints were about odors in air quality, 30% of the total. We will address air quality issues in greater detail in the 600 series. There were also more than 1,300 noise complaints, 38% of the total. That is 274 noise complaints a year, or more than 5 noise complaints each week. That seems just like numbers and statistics, but there's a person at the end of the rope in each registered complaint. Here's a sample of the complaints you can find in the state database. June 2020, a Broomfield resident wrote, "Noise, physically shaking my house. My house is shaking every morning between 3 and 6 a.m. I'm tired of losing sleep." In April, Weld County resident wrote, "I have a special needs child who is nearly impossible to get to bed with this noise. I can't see how this level of noise is acceptable through the night. This work has been going on for about 2 years and I would love to know when it will be done." February 2020, an Adams County resident wrote, "Vibrations throughout the house all night long. I'm pro oil and gas, but this has to stop. We've made beds down in our family room as the vibrations seem to be less on the main floor. How is it we're being forced out of our own house for this? Unreal. I'm tired of not sleeping." Out of the 1,300 noise complaints over the last 5 years, there were only 2 notices of alleged violations. The noise levels set by the Colorado Oil and Gas Conservation Commission are just too high. Now, to discuss the issue of oil and gas noise in greater detail is our expert witness, Dr. Benjamin Blair.
Hi there. My name is Dr. Benjamin Blair, and I'm going to briefly discuss my research published in the Journal of Exposure Science and Environmental Epidemiology regarding residential noise from an oil and gas operation well pad during construction and drilling. This work was completed while I was employed at the Colorado School of Public Health at the University of Colorado Anschutz Medical Campus. Now, in the study, we conducted noise monitoring at 4 residences in various directions located between 1,050 and 1,805 feet from the center of a large multi-well pad in Greeley, Colorado. We measured noise levels over several months. This was conducted between February and April in 2017. This oil and gas operation site was permitted for 22 wells, and the site was reported to have had well pad construction and drilling activity during the period we measured noise levels. This site was also described as using noise best management practices, including a 32-foot sound wall and electronic or modern low noise equipment. Now, we studied noise levels using A-weighted and C-weighted decibels. The A-weighted decibel, or dBA, are noises within the range the human ear can hear. So common noises that you can hear with your ear. We also use C-weighted decibels, which are dBc, and now that is used often to measure noise that one can feel through vibration, but may not be able to hear. The measurements were conducted using professional grade dosimeters and sound level meters, and the complete methods and limitations are available in the published manuscript. At the School of Public Health, we decided to study noise from oil and gas operation sites, as noise pollution is not simply an annoyance. Increased noise levels have been well established in the scientific literature as resulting in public health issues. Now, while research on the public health concerns from noise from oil and gas operations is sparse, significant research has been conducted on other noise-producing activities such as traffic, airports, and railroads. The research has associated noise pollution with health issues such as nausea, headaches, disturbed sleep, impaired cognitive performance, and is also associated with increased cardiovascular concerns, such as myocardial infarction, which is a heart attack, and issues like stroke. Increased A-weight and C-weighted noise levels are both associated with public health concerns. So now in our study, we used 50 dBA and 60 dBc as the cutoff levels that are associated with public health concerns, which we feel was justified by the scientific literature and the support regarding the public health concerns on noise. Yet, scientific research can also justify lower levels. For example, a 2014 review published in The Lancet reported the following summary regarding nighttime noise pressure levels. They reported that 40 dBA is the lowest observed adverse effect level for night noise. At the 40 to 55 dBA level, adverse health effects are observed among the exposed population. Many people then have to adapt their lives to cope with noise at night. Vulnerable groups are more severely affected. And for above 55 dBA, the situation is considered increasingly dangerous for public health. Adverse health effects occur frequently. A sizable proportion of the population is highly annoyed and sleep disturbed. And there is evidence that the risk of cardiovascular disease increases. So at this site, we found the average noise levels at an oil and gas well pad during construction and drilling exceeded levels associated with annoyance, sleep disturbance, and cardiovascular health effects. More specifically, we found that 41.1% of daytime and 23.6% of nighttime measurements were found to exceed 50 dBA. In addition, 97.5% of daytime and 98.3% of nighttime measurements were found to exceed 60 dBc. Now recall that research suggests that levels exceeding 50 dBA and 60 dBc may be detrimental to health. Thus, these noise levels have the potential to impact health of those residing near these operations. In conclusion, our research found that a well pad in the Front Range of Colorado reported to be using the best management practices for noise during construction and drilling had noise exceeding levels of public health concern, even at distances 2 to 3 times the current regulatory setback distance. Thank you.
Thank you, Dr. Blair. Based on the studies we have cited, we're recommending a maximum noise level of 60 decibels C scale and 55 decibels A scale during the day and 50 decibels at night. We've also eliminated the provision that allows noise to more than double during drilling, completion, and flowback. Short term, the public can live with excessive noise, but in a multi-well pad, these stages may last for over a year. We're also recommending the same levels more or less be maintained in areas where there's cumulative noise. We do not believe that Senate Bill 181's mandate to consider and respond to cumulative effects allows the Colorado Oil and Gas Conservation Commission to raise the amount of permitted noise in an area already experiencing high noise levels in order to accommodate oil and gas development. The statement of basis and purpose states that the nighttime noise levels of 70 decibels C was based on a published scientific article by Norman Bronner. It cites the article for the premise that, quote, most people tolerate low frequency noise at levels below 70 decibels C. But in fact, if you read the article, the Bronner article recommends 60 decibels C and states that the maximum for nighttime or 24-hour operations is 65 decibels. We cannot find any support for the state's proposed noise limit of 70 decibels C. Moving to the public water supply protection, we also want to voice our appreciation for the excellent work of the Colorado Oil and Gas Conservation Commission staff and what they've done on this issue. They've been working since November to increase protections for the state's public water supplies. We want to acknowledge and thank the industry for supporting these regulations as well. We hope the industry will continue meeting with our organizations and the Public Water Supply Coalition to address the few issues that remain. Now I will hand the presentation over to Matt Samuelson.
Good morning, Commissioners. I'm going to touch on meter calibration quickly. We support the June 26 staff draft, which included filing an annual meter calibration report for oil and gas wells. We heard yesterday of how the state auditor released a performance audit that found that the COGCC did not ensure the accuracy of oil and gas production reporting because it does not verify that operators have conducted calibrations of measurement equipment. When you cannot verify the meter calibration, the accuracy of taxes and fees owed also cannot be verified. Now, the state examined this issue while looking at severance taxes, but the building blocks, the amount of oil and gas produced and the price of the resource are the same building blocks as property taxes owed to local governments, royalty payments to mineral owners, and fees paid to the conservation levy, on the conservation levy to this agency. Accurately measuring the amount of oil and gas extracted is the first step necessary for determining and collecting the appropriate taxes and fees. But as we heard yesterday, the staff is recommending just posting the calibration report to meter. We have some accountability and transparency concerns with this change. The biggest concern is that not every active well in the state is inspected annually. Over the past 6 years, active wells are inspected about once every 2.7 years. The average, between 2014 and 2019, there was between 17,000 and 23,000 inspections. The concern is that, if staff is requiring the meter calibration reports to be created, maintained, and made available, the next step should be requiring filing the report, preferably using the agency's e-file capabilities, rather than waiting for an inspector to visit the site, which may only take place every couple of years. We just conducted a rulemaking changing the conservation levy rate. We want to make sure that we have accurate measurements so the state can determine and collect the appropriate conservation fee. So our recommendation is to use the staff's June 26 draft of rules 429J3 and 430D3. And that is all we have for you all this morning.
Thank you, panel. Appreciate this evidence and testimony before the commission this morning. At this point, we have an opportunity for commissioners to ask questions of the panel. I would probably dive in first with Dr. Blair. Dr. Blair, you sort of were able to give kind of a broad scale overview of your research. I wanted just to give you an opportunity to dive a little deeper if you had additional information you wanted to present to us relative to the research. In particular, you note that at or above 50, you find that there could be health impacts. Can you sort of explain further, how is it that you arrive at the conclusion of health impacts at that level versus not health impacts at lower levels? What are the health impacts? How do they materialize? Just a little deeper dive in that area would be helpful.
Yeah, it's a great question and something we put a lot of time into, and also it's certainly still a difficult question to answer because of the challenges in getting a perfect regulatory level. So 50 dBA is quite justifiable from a scientific standpoint, as there's been some really excellent studies looking at noise levels that we feel could be somewhat similar to oil and gas operations. So we really focused in on railroad noise, which of course is a different noise than oil and gas operations, but has that vibration. So it has that dBc and has the audible dBA levels. And so we used a lot of the research that was done using railroads, using airports, and using traffic, where they did these large epidemiological studies across huge regions to then get to an understanding of population level impacts, in particular cardiovascular disease. There's a lot of studies done at lower levels of noise. I've seen as low as 33 decibel A is where you start to see impacts in sleep. So some people can be disturbed and awoken by levels just over 33 dBA, which is of course quite low. But what you can then see and what the progression can look like is that this noise can lead to stress and annoyance, which can lead to disturbed sleep, which then can lead to things like particularly inflammation and your body's stress response to these concerns, which then can lead to cardiovascular concerns. So that's kind of the progression that's been suggested for noise pollution and the impacts that you get from noise. And so that's kind of how so the data supports 50 dBA as the level where you start to see these cardiovascular concerns. Below that, it's more, the data supports nausea, headaches, disturbed sleep, and impaired cognitive function, issues like that. So we went with 50 because that's where you start to see the more drastic health concerns rather than the disturbed sleep and the impaired cognitive function. I also think there's certainly an individual response to noise. There's a lot of people that can sleep through anything, and good for them. That's great. But there's also a lot of people that are easily awoken by noise. So I think there's certainly a gradient that has to be considered in how an individual responds. And I tend to gravitate towards protecting the most susceptible, and 50 dBA is a pretty justifiable number. We also use 60 dBc as those levels of vibration. Now dBc has been far less studied than dBA in terms of noise impacts, but the best research available points to 60 dBc as the level where you'll start seeing those impacts.
Thank you for that answer. Commissioner McGowan.
Thank you, Mr. Chair. Thanks for coming and testifying today. I have a bunch of questions, and so I'm sorry if some of these seem pretty basic. Can you remind me again, in your study, you just looked at one well location, and did you look at different stages of production, like the beginning, the middle, and the end?
In this study, we were only at one location. We actually visited quite a few different locations and have a lot of data that we've collected at other sites. We just ended up not necessarily publishing it in peer-reviewed journals. But they tend to agree with what we're finding. This site was, I remember checking the well status during the stages that we were there. And in this study, it was listed as, I think, construction and drilling only. And so it was only during those stages at that time period. You may have a better timeline of what was occurring at this particular site, and we could align our data with the timeline if you have more information. But I think the understanding was that it was just drilling and construction is what it was labeled as, if I can recall.
Could you, I know you said the study had limitations and then we could read it in your study, but if you could just let everybody know what the limitations of your study was, it would save us some time perhaps. Yeah.
I mean, one of the primary limitations, we used two different methods in this study. We used what's called the SLM, sound level meter, where an individual would walk into the field, have to press the button to record, and it would do its automatic recording on the sound level meter. And so we did that intentionally to observe the noise coming from the oil and gas well, the operation itself. So we were physically there pressing the record button, making sure it's not a dog barking or a lawnmower's going or a big truck just went by. So we would be physically there observing the site using the sound level meter. So then the limitation on what's called the dosimeter, where we were doing what is in effect continuous monitoring for extended periods, is that we don't necessarily omit every community noise using the dosimeter, which is why we use the sound level meter to validate the results. So we use two methods to account for that limitation. But that's probably the primary limitation, is that we have, I think, 500,000 1-minute noise recordings. And so we certainly can't go through and remove every single community noise from that. So we made sure to be there physically to validate some of the results using that SLM.
Thank you, Mr. Chair. I was wondering if you mentioned how you thought staff came up with the 70 or the 60 number based on a study, and then maybe it was Matt who did that.
Yeah, that was Matt.
Sorry, Mr. Samuelson, sorry.
Yeah.
And I'm just wondering if our staff might be able to explain a little bit more how they came up with the recommended numbers in the draft version. And that maybe we can do that after we ask questions, but I would like to know from our staff kind of their viewpoint of the numbers that are in the draft. Thank you so much.
Other commissioners with questions? Commissioner Gonzalez.
Thank you. Thank you very much for being here today. Appreciate the insight, Mr. Blair. I've got a couple questions. So, you know, it's a study, right? You know, where there's a scientific method applied to it, and I kind of want to understand that a little bit better. So I'm going to use the wrong words, but I'm going to say it in my layman's terms, and hopefully you understand what I'm saying. But basically, you know, what kind of constants or controls did you use to isolate the noise sources?
So that was tricky, of course. What the best evidence that we have is a baseline study that was conducted either by you or by, it's available on your website as a document. Mr. Sura has the document ID number. And so the best information we have regarding a baseline of what was happening at that site was conducted not by us. We got there only after the site was fully operational. And so the best technique we had to measure it and confirm that the noise was coming from the site was to physically be there and validate it using that sound level meter. So making sure, and this was highlighted in the manuscript, making sure that there was no other community noise, that the noise that we were there using, you know, our best observation was that it was coming from these operations.
And so when you were taking, and they were 1 minute recordings, you said several 1 minute recordings at the site. Did I hear that correctly?
The SLM, I think we did multiple 5 seconds and then did an averaging technique. The dosimeter, we would use 1 minute. It's not exactly an average because of the logarithmic scale of noise, but it's in effect a reading over 1 minute.
Okay.
Using
kind of
continuous monitoring.
So like the human controlling the recording, those were 5 second recordings where you're trying to, you know, not record during a dog barking or a truck passing or any of that.
Yes. So if I recall correctly, it was 3 5 second recordings, and then we would take the average of the 3 5 second recordings.
Okay. And were you, Mr. Blair, there physically on site? I was wondering if maybe someone could describe what they saw on site so we can get a better idea of what the actual operations were at that time, or any photos would be helpful as well.
We have plenty of photos that we can share. Our lab tech, Stephen Brindley, was the one doing a lot of the field work along with Eero Dinkaloo, who is master's in public health. And so they could provide that information, and we can scrounge that up for you, sure.
Mr. Chair, would it be appropriate to ask for maybe a photograph of the location prior to our deliberations so we can kind of consider that, what the actual stage was at the time of the recordings?
Yeah, and I think we can also ask Mike Leonard as well about this information. He'll have some information, and we have him now as a panelist. So if you have questions to further flesh this out, you can certainly do so.
Yeah, then I'll ask this directly to Mr. Leonard. If there's a way that we could more precisely identify the operations going on at the time of the recordings, I think that'd help us understand the data a little bit better.
If I might, the Colorado Oil and Gas Conservation Commission stated that they were in drilling phase during the times that these were recorded. And if I might share my screen again, I can show the baseline information if that is of interest.
I I don't know if that's going to be of terrible interest to me. I think that even though the scout card and the COGCC website may say drilling, there's a bunch of ancillary operations associated with drilling that I'd be curious, how long that status stays in place for, if that's the actual status, the actual operations. I understand where the classification came from, but that may not be as precise as really understanding what was going on, which I think is a valuable part of the data.
Good point. So, Dr. Blair, it was over a period of 3 months, was it not, that this study was conducted?
It was several months. What was it? Yes, but it was over months.
And just to be clear, because of the nature of this drilling and its location, Colorado Oil and Gas Conservation Commission was conducting its own noise evaluations and noise studies, and they had similar data that was presented in the Blair report, finding in one instance that it was on 1 hour average of 57 decibels A and 71 decibels C.
My next question is, you talked about, and I don't want to quote you here, so I'm going to paraphrase what I thought I heard, but that the recommended levels or levels above the recommended levels of 55A and 60C, or 50A and 60C, were potentially unsafe. I was curious if you could kind of quantify that potential for us.
Yes, there has been some quantifications done in other studies. I'd have to get the exact numbers for you as to, there's studies that say at every 5 decibel increase over this level, you get this increase in your risk for cardiovascular disease. I don't have those off the top of my head. But those are the established levels where we start to see population level impacts.
Thank you, Mr. Blair.
Other questions for this panel? Commissioner Messner.
Thank you, Mr. Chair. So I think my question really, and this is again in layman's terms, is there's clearly a difference between A and B or A and C, sorry, and we've heard a number of different folks talk about those as well as staff as far as what the different impacts are and what the frequencies actually feel like. I think what I'm hearing you say is that you're most concerned, and maybe most is not the right term, but that C maybe isn't properly addressed within the rules. I hear you have some concerns about A, but C seems like maybe it has potentially more health impacts than A. Am I understanding that correctly?
You are, yeah. And what's fascinating about the C levels is the conclusion that Mr. Sura showed that I think the commission wrote up of 70 dBc. I cited the same individual, Bronner, in his 60 or 65 dBc. So I find that kind of interesting. But the vibration is a really unique aspect of the noise in these areas. As you're more aware than I, it's very unique to have industrial operations in residential areas. And so it's certainly a unique aspect of these operations in these neighborhoods. And so the DBA levels, while of concern, I don't want to dismiss them, they are of concern. The constant vibrations of DBC that we recorded is certainly something that needs to be further explored and considered.
Okay, thank you.
Other questions from commissioners for this panel? Yeah, Commissioner Messner.
Sorry, I forgot one. So Mr. Samuelson indicated that there was a change from the June 26th draft as far as the reports submitted versus the reports being posted. And I guess I was curious from staff. I mean, obviously there must have been conversations that initiated that change, and I'd just be curious of the background to that and why the change between June 26th and the August 17th draft.
Director Murphy.
Sure, thank you. So the June 26th draft had two options to make sure that we were tracking the reporting or tracking meter calibration reports. And as we looked at it and looked at how to best administer those provisions, the opportunity for the field inspectors to be on site and verifying what they're seeing on a day-to-day basis was a more efficient way to gather the information for the organization. Because the reports that would come in, there are meters that are not owned by operators that we regulate. There are some kind of challenges with gathering those reports and making sure they connect to the correct well and then would need to be audited, et cetera, et cetera. Whereas if we have somebody who is already on site checking a number of different compliance issues, it was much more straightforward for us to be able to just look on site at the calibration report and verify it. So, and I think we would end up auditing more wells on balance actually than if we were receiving reports.
Thank you.
Other questions?
Chair,
All
do you want us to respond to Commissioner McGowan's question?
Yes, please.
Okay. So Commissioner McGowan, I think your question kind of was around how did staff reach the conclusions it did about noise? Is that a fair encapsulation? Okay. So I'm going to start a little bit and then turn it over to Mike, who's the actual expert. But for me, it's, you know, we at the staff level reviewed all of the reports that Dr. Blair has cited, and based on the volume of data and the challenges associated with noise, we made the decisions kind of considering all of those pieces of information. And I would ask Mike to provide a little bit, or Mr. Leonard to provide a little bit more detail about the different constructs and issues that he weighed, because he's been working on the noise issue for as long as I've been with the commission.
Thank you, Director. So yes, we have looked heavily at this, and I do agree there are studies out there that show, especially low frequency noise, and we actually, you know, are in conjunction with Colorado State University, the paper that we cited, it does lay out that there can be health effects from low frequency noise. We have past experience found that anything above 70 dBc does start to affect more and more people. And I think Dr. Blair is correct. Many people, well, everybody's affected differently by noise. Let's just put it that way. We've actually had folks call in noise complaints, and you know, one person will say it's driving me crazy, and the spouse will say, I don't know what they're hearing, right? But again, going back to the 70, we found that once the C-scale level drops below 70, people are able to tolerate it even more, right? And we really want operators to do the noisier, as I explained in my presentation, the noisier operations during the day when background ambient is already higher, right, from traffic and everything else that's around. We want to allow them to do those operations then during the day rather than at night when they're more of a disturbance. There are other studies out there that do equate, that say anything above 65 starts to really annoy people. So that's why we use the 65 at night and the 70 during the day. Does that help at all?
Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if you could talk to me too a little bit about if we're thinking about the duration of when noise is happening. So not just night or day, but like how long you're having to I'm going to use the word put up with noise. So, you know, there's construction happening behind my house. They're putting in a new water main line. I think that's what they're doing. And it's noisy and it's annoying, but I know that there's going to be like this end to it. And so my toleration probably is going to be higher than if I know something's going to be in my backyard for a sustained period of time. And that's why I was asking about during what piece of the oil and gas production, what stage they did their study at, because I'm curious to know what the noise levels are when it's complete and you just have, you know, those tanks sitting there. What are the noise levels, and how does that affect me then as someone who's near that location? Because those things are very different. And I think too, I'm going to go back to community engagement. You know, how sometimes you say to yourself, I can do anything for 2 weeks, or I could do anything for 3 months. Are we communicating with neighbors and saying, this is going to last for 9 months? Or, you know, what's our responsibility too for letting folks know how long you might have to tolerate something? These are not questions that you have to answer, Mike, but they're things that I'm thinking about.
I think I can help with some of that. So I did read the study mentioned. I don't believe it ever gives a location, so I'm not sure exactly where this is at. It says in Greeley, there's been numerous operations in Greeley, and they're right. Just because the scout card or our records say it was drilling, there is lag time in there from the time the well begins drilling until it's completed. And then even after it's completed, that the 5A, I think as was mentioned by Ms. Stanzik earlier in the week, the drilling and completion report, completed interval reports are all submitted, processed, and then uploaded. So when the drilling completion report is uploaded or uploaded into the database, approved, that changes the status of the well. So it's going to say drilling from the time that they gave the spud notice until that 5A is completed. So drilling operations, the drilling operations, the fracking operations, both generate C-scale noise, low frequency noise. They do generate it at different frequencies, okay? So one, and I'm probably gonna get this backwards, but I don't think so. Drilling generates at around 33 Hertz. And I know that may not mean a lot to the people that don't have the degrees. And then the fracking is at about between 63 and 67 Hertz. So it's a different frequency wavelength, right? And it affects people differently. They may not be affected at that 33 frequency, but it may drive them crazy at 67 or vice versa. Once we start into the production operations, now keep in mind, we don't get that far into the details with our sound level measurements. We don't break it down by frequency. We do just go to the overall weighting, right? So all we're going to see is 65 dBc, 67 dBc. And you also have to keep in mind that type 2 sound level meters, SLMs, have a 2 decibel plus or minus error built into them, right? So if I'm looking at my meter and it says 69, it could be 67, or it could actually be 71. So there is that level of that margin of error in all type 2 meters. When you start into the production phase, as long as it's just in the production phase, you don't have a truck sitting on location idling, loading a tank or something like that. Most sites will be or can be mitigated down to below that 50 dBA level. And the C is going to be, what's the word I'm looking for? We'll parallel that, right? There's a few exceptions in production when, and I know I'm going to get way too technical here, but when the separation equipment, which has a burner in it that keeps the liquids hot, if it's not tuned properly, it draws in air, and sometimes it draws in so much air. There's a device on the end of it called a flame arrestor, and what that flame arrestor does, it becomes a reed, okay, just like a wind instrument, and it creates a low frequency hum. We've had this in the past. We've went out and take sound level readings and found them to be out of compliance, and we work with the operator, have them get that tuned in to where that vibration doesn't start. And along the lines of information, you're exactly right. We have found that the operators that have went out and performed community meetings and told people, you're going to see this for this long, you're going to hear this, you're going to hear that, and provide them an avenue for the complaint. So in other words, the public calls the operator first, which obviously that's what industry wants. They don't want us out there investigating and potentially finding a problem. They want to go fix it, and it makes them look better when they fix it. It's the companies maybe that don't inform start to have greater issues, if that helps with your timing question.
Chair, if I can ask a question. I've heard both yesterday and today questions from commissioners about kind of lining up the timing of notices, who they go to, and for what operations. And so that's something that I think staff can put together a more concise or like trackable slide this afternoon. If we spent a little time working on that to help answer some of these questions that to me are all kind of redounding around this question of what information is going to who about what phase. And I know we went over it, but I think it's easy to get lost in the nuance of those questions given the sheer volume of information that's coming in. And we could also try to put together some data about kind of the number of days to drill, the number of days to complete a well in the different basins, if that would be helpful. And we could do that as part of staff's closing, so we have a little bit of time to prep it.
Sure, that can always be helpful. Thank you. Commissioner McGowan, did you have a follow-up?
Nope, that's it for me for now. Thanks.
I'm not seeing other questions from commissioners for the panel. Going once. All right. Thank you, folks, for your presentation today. We really appreciate it around a very important topic. We will have Ms. Larson Zoom you away and bring the next panel, which is Kinder Morgan in. See Miss. And I also would note for the record that halfway during that panel, we had Commissioner Putnam join us. So welcome, Commissioner Putnam. Glad to have you with us. All right, is the Kinder Morgan panel ready to go?
I think we are ready. You have Ana Gutierrez and Mike Hannigan on the line.
Very good. Ms. Gutierrez, if you would like to get started, the floor is yours.
Let me screen share. Okay. Can we see a slide deck up on the screen?
We can. Thank you.
Okay. Okay, good morning, commissioners. My name is Ana Gutierrez with Hogan Lovells. It's good to see you again. I'm here today on behalf of Kinder Morgan CO2 Company, and I'm joined by Mike Hannigan, EHS Supervisor, who will present after me. Issues concerning federal interaction will again be the focus of today's testimony. We want to first put our comments in context. The goal of our proposed revisions is to avoid the situation where the state rules are preempted by the federal rules. In that context, we are not suggesting no state permitting or no state regulation, but given the primacy of the federal government, the state rules must be thoughtful and anticipate conflict with the federal rules. Our asks in the 400 series are twofold. One, let's leverage the coordinated permitting process presented in the 300 series, and two, require consultation before enforcement on federal surface. A theme that you've seen play out in our federal interaction proposals is that coordination is key. If we are clear and articulate on the books about that coordination, we will avoid the majority of issues concerning conflict. Now, let me take one step back. Kinder Morgan's 300 series testimony is really important to understanding our 400 series asks because they are intertwined. If staff and the commission incorporate the revisions to the concurrent and sequential permitting processes that we proposed last week, we expect that concerns regarding the 400 series will be largely resolved. Why? Because ultimately our 300 series proposals allow staff and BLM to recognize and resolve conflicts before they even arise, which we think is everybody's goal. The next step with the 400 series is to be sure that the meeting of the minds that occurred during the permitting process plays out during the course of operations. All of this starts with the 300 series permitting process. The COAs and stipulations developed through permitting typically address those land use matters covered by the 400 series rules. Through coordinated permitting then, the agencies would be on the same page and all COAs from each agency could be incorporated into both permits. But if a conflict arises during the course of operations, how do we handle that situation? Let's expect the unexpected and leverage the coordinated permitting process and resulting COAs. To resolve this concern, Kinder Morgan proposes revisions that defer to the good work put in by both agencies. As you'll note, our proposed text on the next few slides models the concepts in staff's proposed rules 424 and 425. In these proposals, staff recognizes the importance of federal consultation in the context of noise, and it affords deference to the federal agency regarding visual impact mitigation. Other land use measures should follow the same model. The text you see on the screen is a modification of the proposal in our pre-hearing statement because we've revised it to be consistent with staff's August 17 draft. These revisions will ensure that once the Commission and BLM agree on the set of conditions that should be assigned to a particular operations on federal surface, the land use measures in the permits control, and the operator will not be subject to conflicting requirements. Our proposed process is designed to facilitate consensus on COAs that are satisfactory to the Commission and that recognize that BLM has its own statutory mandate and chooses COAs carefully based on site and region-specific considerations. Our final concern pertains to compliance and enforcement actions. Mike will speak to this in his testimony. Our proposed language here on the screen is intended to resolve any of our concerns by requiring consultation with the federal agency before the Commission seeks enforcement. This language that you see on the screen comes directly from the existing MOU with only minor modifications. We believe that consultation is a useful mechanism for resolving differences of implementation between the agencies and should simply be built into the rules themselves. Thank you for your time. I will now pass it off to Mike Hannigan, and I will be available for questions following Mike's presentation.
Mr. Hannigan.
Thank you, Anna. Good morning, commissioners. Can you hear me?
We can.
Okay. My name is Mike Hannigan. I'm an EHS supervisor for Kinder Morgan CO2 Company in Cortez. I have over 35 years of professional experience as a civil and environmental engineer with a significant portion of that time devoted to oil and gas EHS work. My comments focus on providing some examples of BLM's regulation of the topics covered by the 400 series rules. First, our BLM permits typically contain not less than 60 COAs covering everything from visual impacts, downhole requirements, noise and species avoidance or mitigation measures, and more. The COAs are derived from agency resource management plans. They're extensive and site-specific, and they give us clear and specific direction on our development projects and operations. So let me give you an example of the careful and site-specific process we go through with BLM to develop site-specific COAs. We submitted a surface use plan of operation, or a SUPO, for expansion of a facility. We proposed exterior lighting to be shrouded and downcast. During BLM SUPO review, light pollution was identified as a potential issue because visitors come to the area to see night skies and the area has applied for designation as an International Dark Sky Association place. In response to these concerns, BLM asked for further lighting restrictions. In addition to our commitment to install lighting that is shrouded and downcast, we then also committed to turn on exterior lights only during call-outs for upset or emergency conditions that require such use. In my view, this example demonstrates why the agencies should work together at the permitting stage to understand the whole picture and avoid conflicts. I also want to provide an example of potential enforcement concerns. So in January of this year, Kinder Morgan CO2 submitted an interim reclamation plan to BLM for a multi-well pad where only one well had been drilled. The plan reflected BLM's principle that for multi-well pads, interim reclamation does not occur until all wells have been drilled. And in addition to that, we committed to conducting interim reclamation by June 30th, 2023, regardless of whether or not all of the wells had been drilled. BLM approved the submitted plan. Then in April of this year, commission staff conducted an inspection of that location and issued an inspection report with a corrective action that required Kinder Morgan CO2 to commence interim reclamation immediately. Since submission of the pre-filed testimony, that issue has been resolved, and the state did not require corrective action or issue a notice of alleged violation. However, it's worth noting that Kinder Morgan CO2, had we complied with the commission's directive to commence interim reclamation immediately, we would have been out of compliance with the approved BLM reclamation plan. So it's important that we have coordination between the state and BLM to avoid these types of misunderstandings. In the past, unfortunately, the commission has pursued enforcement on federal surface without any coordination with BLM, which can complicate the resolution of any potential concerns. That concludes Kinder Morgan CO2's testimony. I'll reserve the remainder of Kinder Morgan CO2's time for closing remarks, and we're happy to take any questions.
Thank you, Mr. Hannigan. Do commissioners have questions for this panel?
Mr. Chair.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you both for your testimony. Ms. Gutierrez, you went very quickly through some of that information, and so I just wanted to make sure that I understood it. It seemed like there were generally sort of parallels in the process that you're proposing for the various nuisance issues. Could you just describe that one more time, just so that I'm clear in terms of how you see that coordination occurring between your process with the federal agencies and also just making sure I'm understanding the sequence that you're proposing?
Yes, of course. Thank you, Commissioner Nanjapa, for the question. And I'm going to go ahead and screen share again, just so that you can walk through. I'm a visual learner, so I don't know if it's helpful for others as well.
Same.
Okay. So let's step back to the 300 series. I think, so what we talked about last week is our ideal is to go through the concurrent permitting process. I think that's what we all would like to do. And I'll step back to the sequential here in a moment, but the slide on the screen shows the concurrent process, which would allow us, the proposals that we had last week were leveraging the information and data submitted in the federal APD so that we're all looking at the same information and analyzing that information. And again, through our conversation, Commissioner Nanjapa, we do think it's appropriate for the state to ask for additional information if you think there's something else that hasn't been presented to you that you want to see. We think it's really important that staff participate in that BLM on-site visit, because that has proven to be one of the most productive tools and essentially milestones, as we're calling them, to reach consensus on issues that would be analyzed, potential resource impacts and concerns, location analyses, issues that will play out through the rest of the analysis. And then to the extent the feds finish their NEPA analysis before the state, we would want the operator and the federal agency to be able to provide that to the state to further inform your analysis. And then ultimately that comes out through coordinated timing. So there's not lag time by either agency. In the sequential process, the way we do this, and sorry, let me take one step back. through the concurrent process, you would also have coordination between development of the COAs. So that's really the crux of what these permits come down to, is how the operations will be allowed to operate on a site-specific location. We address that more in the sequential process because in that process, you will have gone through a full federal APD process, and then there was a proposal that the commission would potentially add additional COAs where it thought appropriate. We think it, again, is appropriate for the commission to make its own evaluation and own proposals for additional COAs. We're just asking that you consult with the federal agency, with BLM or Forest Service, before doing so, to make sure that it makes sense with their whole holistic and comprehensive resource management plans. Same concept for the ALA. So after we have a permit through either of the coordinated permitting processes, the concurrent or sequential, we have a universe of information that will have been discussed between COGCC and BLM. What we're doing with what we're suggesting with the 400 series is we don't want all that good work to go to waste, right? So we have sat down at the table, we talked about what the potential impacts might be of these operations, and we talked about how we resolve these, and we agreed upon those resolutions. What we're saying for the coordinated, for the course of operations, is that to the extent there is an inconsistency between the state rules and what has been agreed upon in the federal and combined federal and state permits, which includes the COAs, stipulations, and plans, that those COAs, stipulations, and plans will control. Otherwise, we're back to square one and having to have the same conversation that we had when we went through the concurrent permitting process. Is that helpful?
Follow-up?
Yes, thank you very much. That is helpful in terms of what you're proposing. I have two quick follow-up questions. One, just again, making sure, I think what you just stated might clarify, but where it said no veto power, so you're saying that once there is this process that is engaged in concurrently, that despite any other inconsistencies with the state rules, that we would defer to the federal rule? Is that what you're requesting?
So the no veto power, sorry, excuse me. Thank you, Commissioner Najapa. The no veto power primarily relates to the concept of permitting itself. It's not necessarily during the course of operations, but that relates back to our 300 series proposal. So that implicates the preemption doctrine in that there is case law that states that if a federal government has authorized a use of federal lands, and in this case where Kinder Morgan, just as a point of reference, is operating on a federal unit as well as federal surface, once the federal government has authorized that use, the state cannot deny operations, those same operations. So it's just an overarching inability for the state to veto, and we had some clarifying language in the 300 series that with respect to federal surface, it kind of pulled back on the way that spoke to COGCC's authority.
Okay, thank you. I appreciate that clarification. And then I had one more, if I may, Mr. Chair.
Absolutely.
Thank you. So let's see, I guess actually this maybe would be a little bit more for staff and perhaps could be just touched on in closing, but wanting to better understand our basis. I believe this may be in the SBP, and so I can look back through that, but with respect to the preemption notion that Ms. Gutierrez just described. And then lastly, my question was also for either Ms. Gutierrez or Mr. Hannigan. You described an example of where modifications were made for the lighting and due to light pollution concerns. Have you had examples of modifications that have needed to be made with respect to wildlife or the presence of high priority habitat or certain seasonal considerations? And can you describe an example of that?
And I'd be happy to start, Mike, and feel free to jump in after I provide this example. But that is one particular issue that is probably where we would see conflict, at least conflict in terms of mitigation more often than not, because as you can imagine, public lands are primarily rural, right? They are open space by definition. And so we are not dealing so much with impacts to people as much as impacts to the environment, and how do we mitigate that? So one of the concerns that we have is, for example, with noise and how we address noise on federal lands versus how COGCC might propose. And that's why we think it's important to have this coordination, which is already reflected in staff's rules at the 424B with high priority habitat, but we think that can be expanded. But we've seen that with respect to noise, to mitigate it, oftentimes staff would propose sound barriers or sound walls around an oil and gas operation. And on federal surface, that often creates significant concerns and even more negative impacts for species. In particular, if you're in sage grouse area or some kind of corridor where there is a traverse of a species, that large visual obstacle will negatively impact the species. So we would want to avoid that and go with the BLM mitigation, which typically is a timing restriction versus a visual sound barrier.
Mm-hmm.
And Mike, I don't know if you have anything else to add on that.
Yeah, I'd like to say that we've had an opportunity to do an on-site recently with the Forest Service, and we invited COGCC. Unfortunately, Dave Cabesco was ill and couldn't make it, but Colorado Parks and Wildlife representatives were there. And we were able to sort out wildlife issues. It happened to be an elk calving area that was critical. And we were able to sort out the issues, move the location slightly, make adjustments. And I think we avoided a lot of conflict down the road by having everybody present at the first on-site, before we even started the APD process with BLM, Forest Service, or COGCC.
Thank you, Mr. Hannigan, for that. And for the panel, I appreciate the sort of nuance of collaboration, and that's certainly, I think, where COGCC has been with regard to its relationship with BLM and where we plan on going with regard to this rulemaking. But I would like to call upon Attorney General Minor to provide his perspective on preemption. I believe we have a couple of lawyers with a couple of different mindsets on this, and I would like the record to be clear on that point.
Certainly, Mr. Chair. Can you all hear me all right?
We can.
Thank you. So I would once again agree with many things that Ms. Gutierrez said, but respectfully disagree with several of her characterizations of the nature of the legal relationship between state and local governments. And so just for background, I will reiterate the same framework that I provided in earlier presentations in the 300 series about the relationship between federal agencies and the COGCC. Again, all agencies are creatures of statute. So the federal agencies that we are primarily talking about, the Bureau of Land Management, is implementing, in particular, two federal statutes, the Mineral Leasing Act of 1920 and the Federal Land Policy and Management Act of 1976, which is better known as FLPMA. The Mineral Leasing Act of 1920 recognizes that states do have authority to regulate oil and gas development that occurs on federal lands and that involves federal minerals. That is found in sections 30 USC 187 and 30 USC 189. Both recognize that states can continue to regulate oil and gas operations on federal lands, as indeed all states that have federal minerals do. Similarly, the FLPMA statute, which is BLM's organic statute, it is the statute that sort of gives BLM its surface management authority, also recognizes the need for the federal agencies when regulating to provide for compliance with state standards, and particularly with state environmental standards. Unfortunately, don't have the site for that off the top of my head, but I believe it's 43 USC 1712. So within that framework, of course, Colorado and other states continue to exercise their authority to regulate oil and gas, and when there is a conflict, and I do want to emphasize that this preemption analysis only comes up in the event of a conflict, right? So I think, as I believe Mr. Hannigan just said, for the most part, and I believe in all cases that I'm aware of, the COGCC staff are able to work very well with our federal partners, and so these conflicts really don't come up. I think that the framework of the Memorandum of Understanding that has been in place for a long time is really effective at allowing the agencies to collaborate together and to work with operators to avoid the conflict. But should we be in the unlikely situation of an actual conflict that is just not resolvable that gets to federal court, since the 1980s, in a case called Granite Rock, the US Supreme Court has generally recognized that states do have authority to adopt environmental regulations that are part of sort of their reasonable environmental powers to regulate things that happen, even if those things happen on federal lands. And subsequent court decisions have recognized that state authority is particularly broad with respect to wildlife concerns, which I think is some of the concerns that we're specifically talking about here. Federal agencies do, of course, have land use authority over federal lands, and where the exact line of land use versus environmental authority is, it's not always easy to tell in every case, but I think that the rules proposed in the 400 series are sort of well within the environmental and public health, safety, welfare authority that the commission does have to regulate on all lands throughout the state of Colorado, regardless of whether the land management agency is a federal agency, a local government, or even another state agency like the State Land Board or Colorado Parks and Wildlife.
Thank you, AAG Minor, for reiterating that point in a collaborative manner. Are there further questions for this panel? Commissioner Putnam.
Thank you, Mr. Chair, and had a question for Ms. Gutierrez and maybe Assistant Attorney General Minor as well. And that relates to the proposal to include in the rule a requirement that COGCC engage in coordination before any enforcement activity. And just trying to understand why that should be in a rule as opposed to being just general good practice that I think certainly my department and I think COGCC would engage in that kind of coordination. But given that there's independent legal authority requiring that as a requirement and rule seems unusual to me. So interested in further comments on why it should be in a rule as opposed to just being part of general good practice.
Ms. Gutierrez.
I'm happy to. Thank you for the question, Commissioner Putnam. So I think from our perspective, you're right. It has been general practice as laid out in the MOU, because the language we proposed is directly from the current MOU between BLM, Forest Service, and COGCC. I think a little bit of part of the concern is that we haven't always seen it put into practice, at least from Kinder Morgan CO2's perspective. And while that might be the exception and not the rule, we think it's an important enough practice that it should be in a rule, and it should, you know, if it's something that we would expect COGCC to do anyway, I don't know that it's harmful for it to be in the rule.
Attorney General Minor or Commissioner Putnam, follow up?
Yeah, just one follow up. So what would be the consequence then in the future if it were included in the rule? Would that invalidate an enforcement action if COGCC had not coordinated with BLM in that process?
Mr. Chair, if I may.
Or Mr. Minor.
Commissioner Putnam, I think that is certainly one of the reasons that staff has not proposed to put that in the text of the rule. I think it could be raised as a potentially valid affirmative defense by an operator if there was a requirement in the rule that staff do certain things prior to initiating an enforcement action that for some reason didn't happen. And I think that that sort of procedural roadblock might not be to the benefit of really anyone involved. But I think to a broader point, as Ms. Gutierrez just said, staff's preference is not to put that in the rule because it is currently in the Memorandum of Understanding. That Memorandum of Understanding does certainly govern and bind the Commission's behavior subject to the constraints of the Memorandum of Understanding itself. It's been in place since 2008, and I believe as Ms. Gutierrez mentioned, the intent is to update it and for staff to work with our partners in the federal agencies, BLM, the Forest Service, perhaps even other federal land management agencies that have surface authority in Colorado. And if there are provisions from the MOU that are put into the rule that doesn't allow us to revisit and update them as appropriate in that next round of negotiations, because then we would be firmly bound by them until you as the commission revisit them in a rulemaking, and even in the future, it doesn't give quite as much flexibility to really adjust that relationship as needed. And I think that the other thing that's really important is obviously Ms. Gutierrez and her clients have a very close working relationship with the federal government, but you are hearing this suggestion from an industry party, not from the Bureau of Land Management itself. And I think there would be a little bit more comfort from staff's perspective if a suggestion to codify components of memorandum of understanding in the rule was indeed coming directly from our federal partner agencies, so we could really be entirely sure that that is the intent that they have for the way that the best, if that is indeed their intent, the best way to govern that relationship is by codifying components of the MOU into our rule.
If I could, just a second, Ms. Gutierrez. If I could call on Director Murphy, I know that you have been firmly engaged in discussions with BLM and the collaborative relationship there around that. If you could add some perspective to that as well, please.
Thank you, Chair. The relationship with our federal partners is incredibly important to us as an organization for any number of the reasons that Ms. Gutierrez, Mr. Minor, or Mr. Hannigan have articulated this morning or last week. And we have worked closely on staff's proposed regs, and in particular on the language that came out on 817. I have had some conversations with, well, conversations is probably an overstatement, but I've traded texts with some folks at BLM that, you know, we should look at Kinder Morgan's language, and we have. And my concern as I look at different regulatory provisions are, who are we regulating with the language for the most part? And in some of these instances, I worry that we're treading into the space of actually trying to regulate the BLM and forcing them to consult with us or forcing them to pick up the phone if we call. And so and that to me is the heart of an MOU, is how do we work together on that space? But I think what's critically important is that we as an organization carve out space to coordinate with our federal partners. And that's to me at the heart of what the 817 draft does in terms of creating the process, creating the expectation that our permitting system will bring in information prepared as part of a federal process. And to avoid some of the concerns that Mr. Hannigan articulated. And I was grateful to hear, and it was consistent with what I understand, that the issue that he brought forward from the summer did get resolved in a helpful way. But it articulates the concern about having kind of three different folks involved, right? Both COGCC, the federal government, and operators, and making sure there's seamless information can be difficult. And when things happen in the federal process, like a change to an interim reclamation plan, that also needs to come to us, or our field inspectors aren't able to consider it when they're on site. And so again, I think that worked out well, but it's a mutual relationship. And the goal here is to take advantage of information prepared by the feds, given their deep expertise and deep responsibility in regulating our federal lands. And but there's also a lot there. There's also a line here that I get nervous about crossing in terms of either our rules stepping into the space of regulating a local government or regulating the local government the federal government and how it engages with COGCC. So that was a bit long-winded. Apologies.
Thank you, Director Murphy. Ms. Gutierrez, did you have follow-up?
Mr. Chair, if I may, briefly, and thank you to AG Minor and Director Murphy. Those are both really important conversations. I think I just want to respond to 2 points. One made by AG Minor with respect to, putting rule language in the rule that would have COGCC staff seek consultation with BLM before an enforcement action. I think I would respectfully disagree that that is just a procedural process. I think ultimately it is intended to be substantive, so we don't get to the point at which we have sort of competing opinions, because a lot of times what would happen, or what has happened, is there will be a conversation between COGCC and the operator, and then a separate one between BLM and the operator. And so the operator's sort of in the middle between two competing opinions. So our goal ultimately, I think, is all the same, is that we're trying to bring everybody to the conversation together, and putting that in the rule provides regulatory certainty, which I think is an important component to industry and regulators alike. The second point I want to respond to is that from Director Murphy regarding who we are regulating. It's a really important question and a really fine line that we all have to walk. But the way that we've proposed and attempted to phrase our language is not requiring BLM to do anything, right? If BLM doesn't, there's sort of the if applicable. If BLM doesn't have an on-site visit, or if there is not, invitation, I think that's understood. But it's both what we were trying to build off of is your proposal that the operator would notify you of the on-site visit, right? So that onus falls on the operator, and then that operator has informed COGCC. But we do think it's an important enough milestone that if that invitation is on the table, COGCC participate, because I think, as Mike described, so much information is shared and resolved at that very early stage, and that's just one example. So ultimately, yes, I think we need to carve out spaces where that coordination can happen. Our goal is to make it as clear as possible, because an MOU is an MOU, whereas the rules themselves provide that regulatory certainty and process that I think is necessary in this type of relationship.
Thank you for that. I, just as a commentary, think that we're sort of going around in circles on an area in which we really have a lot of consensus, and we've really done a good job with the BLM, Serena, and I, for one, am not excited to start codifying things that we've done really good jobs with our MOU and with our federal partners. And I think to a certain extent that, with all due respect, a lot of the things that you guys are worried about, you ought not be worried about. I think that the COGCC, the BLM, and our operators that operate on federal lands do a darn good job of collaboratively addressing both the BLM and the COGCC permitting protocols. Are there any other questions for this panel?
May I will take 20 seconds just to respond to that, Chair Robbins.
I'll give you 10.
Fair enough. My last ask is I would just ask that staff take some time and maybe sit down with BLM and talk through some of these proposals in a little more detail. And I'll leave it at that.
And I think that they are and have been and will continue to do that. Thank you very much. With that, we will Zoom this panel away. Thank you for your presentation. We appreciate your attention to these important points that staff has in the past and will always in the future continue to work on. With that, Ms. Larson is already Zooming in our next panel. It's the Western and Rural Local Government Contingent, as well as the City of Greeley and Los Animas County. I see Mr. Jacobs is in the house.
Yes.
You're generally lead, so I will turn it over to you.
Want to make sure we've got slide sharing capability. My associate Hayden Weaver will be doing that for us. And then we'll get started.
All righty. I see that Mr. Weaver is with us as well.
Yeah. And Mr. Vaughn, do you have your video going as well? I'm not seeing our witness. There we go.
There you go.
Very good. Thank you and good morning, Chairman Robbins, Commissioners, Director Murphy. John Jacobs again here representing the Western and Rural Local Government Coalition. With me this morning to provide testimony on the 400 series rules are Matt Lepore, President of Insight Energy Law, Kirby Wynn, Oil and Gas Liaison with Garfield County, and Phil Vaughn, President of Phil Vaughn Construction Management, Inc. We want to clarify at the outset that WRLG supports the great majority of staff's proposed technical changes to the rules in the 400 series, as Kirby Wynn will explain further. Kirby?
Yeah, appreciate it. I just want to take a moment and express our support, appreciation of staff's great work and stakeholder engagement on the 400 series rules. I think you've landed a good place in a lot of it. we support 33 of the 36 draft rules. So I think that's really saying something, and it's a credit to your staff. And with that, I'll pass it off to Matt Lepore to discuss a couple of rules where we have some suggestions.
Thank you, Kirby. Good morning, Chairman Robbins, Commissioners, Director Murphy. First, I want to thank you all for your continued close attention to so many varied, challenging issues. Really appreciate that. I want to thank staff for your presentations yesterday. I thought they were terrific across the board. Some graphics slightly better than others, but all really great. Appreciate it. Finally, I have to express my appreciation to Mike Leonard and AAG Minor for collaborating with a group of us very closely on the technical aspects of Rule 423. And I think landing us all in a better place, so appreciate that. My comments this morning focus on 3 rules, 422, 423B3C, and 424DC3. Starting with Rule 422, which is Local Government Welfare Protection Standards. I just want to acknowledge and thank staff for changes to that rule that were made with the June edition and carried into the August edition. We think that as written, Rule 422 aligns with coordination between local governments and COGCC with respect to co-regulating the nuisance issues that are addressed in 423 through 427, and which are issues traditionally regulated by local governments using their land use authority. So appreciate those changes to 422. 423B3C and 424D3C, sounds like an airplane, relate to noise and light respectively, and they provide off-ramps for local government and COGCC to collaborate and to maybe align on slightly different standards. So number one, we appreciate these being included. We think those off-ramps are important and give local governments and COGCC flexibility to tailor rules for different circumstances and different land uses and different land use decisions by local governments. That said, we'd like to ask for one word to be changed in each of those 2 rules. That is to change the word may to the word will, on the basis that you have built in some safeguards to the rule. There are 3 conditions that must be met for the director to approve this. The first condition is that the rules, the standards would protect public health, safety, welfare, and wildlife. The second and third conditions are agreement by the relevant local government, proximate local government on the standards. We would suggest that if all of those conditions are met, the decision by the director should not be a discretionary one, but should just be a green light. So that's our ask. We appreciate it. I'll stop there and pass this to Mr. Vaughn.
Thank you, Matt. Good morning, Commissioners and Director Murphy. My first comment and request is in regards to Rule 411A, surface water supply areas. I have extensive experience in Garfield and Rio Blanco counties in permitting and construction of water recycling facilities. In my experience, water recycling facilities have the following benefits. Firstly, it greatly reduces truck traffic. This reduction in traffic has a clear benefit to neighbors and local government and reduction of impacts. Secondly, it reduces freshwater usage for drilling and completions. Freshwater, as we all know, is precious and scarce resource in Colorado. And thirdly, it reduces the need for injection wells. WRLG supports the West Slope COGA suggested revisions to Rule 411.A sub 2, capital B, Roman numeral 6, and the associated Table 411-1. These revisions provide clarity that naturally occurring constituents in the local area can and will be present in produced water. For the reasons I've just stated, it is critical to support the recycling of water for use in completions. My second comment and request is in regards to Rule 423 noise. The rural land use designation should be placed in the commercial agricultural land use designation. The reasons for this include, first, rural zoned areas in Colorado have much less population density than areas in residential zoning. Secondly, drilling and completions are a relatively short duration. Thirdly, the difference between rural land use designation and commercial agricultural land use designation is 5 decibel. This increased 5 decibel is reasonable in a rural zoned area. Rural zoned areas have great similarity to agricultural zoned areas. Agricultural zoned areas already have seasonal noise impacts during the course of cultivation and harvest. Drilling and completions are a relatively short duration and thus are similar to seasonal agricultural operations. My third and final comment is to note the appreciation of WRLG for the staff August 17 revision of Rule 423B sub 4 regarding coordination on noise in high priority habitat. The critical coordination with the BLM and U.S. Fish and Wildlife Service on federal lands to determine acceptable noise limits is encouraged and appreciated. And frankly, this process is similar to coordination with Colorado Parks and Wildlife on private property. In my opinion, the continuing partnership between local governments, operators, Colorado Parks and Wildlife, and the COGCC is critical. I'll turn this back to Kirby Nguyen. Thank you.
Thank you, Phil. Now for the commission, I'd like to take just a few minutes to share how local governments can do already regulate oil and gas to protect and minimize 400 series type nuisance impacts for the residents. Using Garfield County as an example, beginning 17 years ago, they hired dedicated staff for the primary purpose to protect public health, safety, and welfare, and to provide rapid intake and response of resident oil and gas issues, including lights, odor, traffic, dust, and noise. We find at least 90% of complaints in our area come to and are addressed by the county, working with operators directly, and as needed with some follow-up assistance from Oil and Gas Commission staff. By orders of magnitude over all other options, county staff are in fact the first responders for citizens experiencing nuisance issues in our area. One reason we're the first call most people make is we are local. Everybody has our cell phone, in my case, my cell phone number. And most importantly, we can vastly decrease the amount of time the resident is feeling impacts by taking these calls essentially 24/7, weekends and holidays included. Based on 9 years of my receiving calls, emails, and texts at all hours of the day, the data show 80 to 90% of all complaints do come during the several months of drilling and completions, and we find long-term production activity only occasionally causes issues. Our western and rural natural gas areas where oil and gas facilities generally have far fewer human receptors as compared to front range sites is something to note. Our experience suggests the commission will best protect Coloradans by addressing the short-term duration pre-production nuisance issues as compared to long-term production periods when sites are relatively quiet, they emit less, and they draw far less truck traffic. So just to summarize a little bit, I hope we are encouraging you to infuse nimbleness into the rules by incorporating local governments into the process to minimize nuisance impacts in the first place, and to also help you address nuisance impacts as immediately as possible. We believe that is best achieved by first trusting local governments who regulate oil and gas, and then holding them accountable to share the burden on a daily basis. This includes local governments setting site and situation specific performance criteria consistent with their regulations, and ensuring their criteria are complied with and that they will be as protective of public health, safety, welfare, environment, and wildlife as anticipated, and also, of course, as is required by the commission. What is it they say? Trust but verify. Perhaps the commission creates a process for local governments who pick up the regulatory mantle to provide details on how they will receive and address issues and report back to the commission annually or in some frequency. Over the next couple of years, we could all have a comprehensive data set in hand to inform rules adjustments to further expand achievement of Senate Bill 181 mandates that minimize nuisance issues. I recall Chairman Robbins the other day speaking just to this topic of how such a check-in on how things are working being advisable at some point in the near future, maybe in a year or so. I'd like to move on to talk a little bit about the statement of basis and purpose. Within the statement of basis for Rule 304, the Commission provided an off-ramp for lesser impact areas. The Commission recognized not all proposed oil and gas locations have equivalent impacts. We agree. Accordingly, the Commission created regulatory options to apply more relaxed mitigation planning for areas where oil and gas operations are likely to have those lesser nuisance impacts. The examples given were locations away from areas of human use are unlikely to cause odor-related concerns. That makes sense and is perhaps analogous to the words of philosopher George Berkeley, who said, if a tree falls in a forest and no one is around to hear it, does it make a sound? Quite simply, required mitigation should be adapted according to surrounding land use in the presence or not of receptors. An example could be, does a well pad with no homes within earshot and no sensitive wildlife present need costly sound walls to ensure sound levels meet residential standards in a rural area and other places? The same would apply, again, I guess I did mention that, the wildlife receptors. The stated basements and purpose went on to say, an operation to drill a single vertical well from a well pad is likely to have less of an impact on public health, safety, welfare, and environment and wildlife resources than a large multi-well pad with horizontal wells. We appreciate that common sense thinking and ask that you expand on it a bit further. For example, Western Colorado natural gas activity presents far lesser impacts for shorter durations than front range crude oil locations. Our sites and equipment and traffic impacts are smaller, the sites emit less into the air, and the boreholes are shorter, and horizontal drilling is rarely an option because of our geology. Regardless, I really want to emphasize we appreciate off-ramps provided by Rule 423B3 sub C for appropriate, relevant local government approved flexibility on allowable noise. We certainly understand and we absolutely appreciate you are drafting rules that need to work for Boulder, Erie, Adams, and Weld, as well as Western and rural counties. We believe 423B3 sub C, with our suggested edits, provide an elegant solution. And with that, I thank you all very much for your time, and we'd be happy to entertain any questions.
And we would like to reserve any remaining time for a possible closing statement. Thank you.
Thank you very much, Mr. Jacobs. Thank you, Mr. Nguyen, Mr. Lepore, Mr. Vaughn. I, for one, appreciate the sort of the tenor and tone of testimony today. I am interested in the suggestion from Mr. Lepore and would ask staff to look into that, make sure there's no unintended consequences, but at first blush, that seems like a good idea. I would note, Mr. Nguyen, yesterday, I think I said this, or if I didn't say it, I was thinking it, that these areas around nuisance and welfare, I think this is a really good spot for if the operator has, gone into a local government and had these issues vetted through and come out with a permit, and could be some substantially equivalent information that could be submitted to the state for consideration of whether it's protective, and perhaps not have to redial the wheel on that. I think Attorney General Minor sort of echoed that that's precisely what the staff was thinking. So I appreciate all that. I want to challenge staff, if you can find a way to incorporate the word nimble into our rules and regs, I'll be really happy in today's day and age and in pandemic. So Ms. Murphy, your task is before you. So apologize, I normally don't just spout off with commentary, but I wanted to acknowledge the collaborative spirit of the testimony today. And with that, I would turn this to Commissioner questions to this panel. Commissioner Putnam.
Thank you, Mr. Chair, and thank you to the panel for your presentation. Had a question for Mr. Vaughn and also for staff, and that relates to the question about the chemical additives and the effects that could have on the reuse of water. And looking at the most recent version, the August 17th draft of section 411A to B sub 6, which rolls right off the tongue. I guess the question for Mr. Vaughn is that given the current formulation of the language to focus on additives and to specifically say that it doesn't prevent operators from recycling or reusing produced water that may have trace amounts of that, is there something more that's needed to address your concern about discouraging or prohibiting reuse, or has this evolved in a decent place? Because I know in previous versions there were that concern, and I'm just struggling to see where the concern is now and what specific changes we would need to address that.
Sure. Understood.
Thank you, Commissioner Putnam. That's an excellent question. I'm glad you covered it. Turn to the panel for thoughts about that.
Thank you.
Kirby, do you want to weigh in on that, or would you like me to?
I think I will. I think the rule as crafted we think it's fine. The reason we brought up the reuse is because it's such a critical and a wholly, completely beneficial process in our area. We take production water with all this barium, selenium, whatever, just as it came out of the ground, and it gets put back right exactly where it came from to do the completions on another well. Our only concern was, again, everything's up to debate and change, and y'all are going to consider things. We just want to highlight, please don't allow other parties, I don't know if anybody's planning to, but don't let other parties come along and turn it into some kind of a threshold, or look over at your 915 table and say, wow, if that production water has this naturally occurring element in it, you've got to treat it and remove selenium or barium before you put it back in the formation it came from. So it's just more of a proactive approach to make sure you understand the benefit and not have someone hem you into doing something that crushes an extremely beneficial process in our area to prevent use of fresh water for completions.
I would just add that the concern is primarily the naturally occurring contaminants, as Kirby and Phil mentioned in their testimony, and less so the additives that might be used by an operator and that maybe there are substitutes for. So let's just not prevent that reuse unintentionally with table values in 411-1 or the 900 series, for example, that are well intended but would prevent this beneficial reuse of produced water.
Thanks for that clarification.
Thank you, Mr. Putnam. Thank you, panel, for the answers on those points. Other questions for the panel from commissioners? All right. Seeing none, again, thank you, panel, for your presentation on 400 series. Always exciting to see that there is consensus on the vast majority of 33 of 36 draft rules, with some smart suggested edits to the other 3. So thank you again. We will dismiss this panel, and Ms. Carson, look to you. Looks like we have one more panel before our proposed break at 10:50. That's La Plata County, San Miguel, and Pickett.
Thank you, Mr. Chairman, commissioners.
Thank you.
Good morning to my West Slope neighbors. Speaking to you from downtown Denver. Good to see you all. Do we have Ms. Rogers joining us as well? Oh, I see County Engineer Mr. Davis. Good to have him on board as well.
Ms. Rogers won't be on this series, Mr. Chair.
Okay. Do you have your panel before you then?
I believe, yes, we do. Again, my name is Maki Iatridis. I represent La Plata County and San Miguel County. The 3 counties will have 3 witnesses today. Commissioner Julie Westendorf, Director Lynn Padgett, and then, as you noted, Public Works Director Jim Davis from La Plata County. And Mr. Chair, you can just go from one witness to the next without coming back to me. Thank you.
Why don't the witnesses, Joe, go from one witness to the next, and you don't even have to get me involved?
Okay.
Commissioner
We do
Weston.
that. Thank you and good morning, commissioners and Mr. Robbins. I'm Julie Westendorf, La Plata County Commissioner. Again, that's the southwestern portion of Colorado in the Durango area. Today, I'll be speaking on Rule 423, noise standards, and 425, visual mitigation. The counties ask that noise standards in rural areas take rural ambient conditions into account. One of the most regular complaints that we commissioners hear about is the sound that energy facilities create in an environment with little background noise. Many of our residents live in quiet rural areas, and such country settings can make more intrusive the noise generated by an industrial use like oil and gas facilities. Our specific recommendations occur on page 10 of our pre-hearing statement. In addition to asking for consideration of the A scale and noise analysis, we also request that the word may be changed to will in regards to consultation with local governments. Rule 425. Since 2007, La Plata County has used visual mitigation guidelines for oil and gas facilities. These guidelines have served as a model for other local governments. The visual mitigation guidelines were attached to the county's pre-hearing statement as Exhibit 4. These guidelines have worked well for La Plata County and landowners, operators, and other stakeholders in making educated decisions on which best practices to use. The guidelines are also important to facilitate the decision-making process. We ask that the COGCC adopt many aspects of these guidelines into the proposed rule. Finally, it is important that ongoing maintenance of the mitigation measures be required. Specifics for our recommendations are on pages 10 and 11 of our pre-hearing statement. Just an example is a provision for the reduction of contrast between the facility and existing surrounding landscapes. I'll pass off to Lynn Paget. Thank you.
Ms. Paget, you're on mute.
Okay, sorry about that delay. Good morning, Commission. You can hear me, I hope.
We can.
Excellent. Well, my comments today are in the context of the 400 series, but they do connect to rules in the 200 to 600 and 1200 series. I have 3 requests I wish to highlight from our submitted testimony and statements this morning. First, more direct and advanced local government notice of operational activities at existing wells and facilities is needed. Why does San Miguel County keep asking for notices to be shared concurrently with the Commission and local governments? Well, we have several small oil and gas fields. Our active wells range from 1 to 6 decades old. Our wells are vertical and were developed during the Commission's Foster era. Wells are located in extremely remote areas, hours from where emergency responders mobilize. Operations may only take place a couple times a year, so we are not always standing by. We need situational awareness. Hopefully, the Commission can see value in providing local governments with concurrent notice and also requiring notices to be provided to the Commission and local governments at least 5 business days in advance of mobilization for the good reasons we have explained. Next, we are asking for Colorado Parks and Wildlife, CPW, and the Colorado Natural Heritage Program, CNHP, to be consulted when there are operations at existing wells that may have been located in sensitive areas during the location siting, which for us, again, is 10 to 60 years ago. Our existing facilities are unfortunately also located in sensitive and critical habitat for big game and raptors. 55% of our wells in our county intersect habitat areas important for the threatened Gunnison sage-grouse. The Commission appears to assume that protective stipulations and timing limitations were applied when the wells were located under the 300 series in Form 2s. Our wells did not go through a meaningful alternative location or cumulative impact analysis for on-site and access impacts. They were not located to protect public health, safety, welfare, the environment, and wildlife resources. We do now have the opportunity through communication and consultation to do better. CPW and CNHP are state agencies and experts on different species of wildlife and plants. With increased communication and modern science-based wildlife and sensitive species information, we can now reduce unnecessary impacts from human activities at existing wells going forward. Seismic exploration, wellbore integrity, fracking, reclamation, these operations could simply be reviewed in time to avoid making additional adverse impacts from human disturbances during critical periods like lecking, new nesting and brood rearing, or severe winter concentration periods. And then last, I want to echo Julie's testimony, Commissioner Westerndorf, on the additional visual resource protection needed in the rules. Visual resources and our natural scenic beauty are vital to our tourism economies and quality of life. Incorporating the additional proven visual resource protection strategies will minimize the impacts of oil and gas, this economic sector, on our other economic sectors as we strive to keep our economies diversified and thriving. Thank you very much. Our next witness is Jim Davis, La Plata County Public Works Director.
Go ahead, Mr. Davis, if you could unmute yourself. Stop the clock, Ms. Larson, until we...
Good morning, Commissioner Robbins and Commission. Can you hear me?
We can. You might get a little closer to your mic.
How's that? I'll try and speak up.
That's better.
Okay, good morning. I'm the Director of Public Works for La Plata County, a position I've held since 2006. Before that, from 2001 through 2005, I was a project engineer for the county, and I've been involved with a lot of the mitigation over the years with the impacts from the industry to roads and bridges. My background, I'm a civil engineer from graduate from Colorado State University, and I've been involved in land development and transportation since I've graduated. Obviously, my interest on behalf of the county and public works is to identify and mitigate public safety, road capacity, and maintenance issues. And we've had a pretty good history, a pretty good working relationship over the years with the various companies. And in fact, for a number of years, one of the larger companies we worked with, I think from 2005 through about 2009, they would give us a list of their rig moves and their projects for the upcoming year, and we in turn would share with them our road maintenance schedule and the list of projects we had, so we could try and minimize the impact to each other, our impact to their moves and their impact to our work on county roads. That worked quite well, but as you know, people and companies come and go, and to try and maintain consistency in that process had been difficult. Along those lines, we appreciate the improvement to Rule 412A4 with the 7-day advance notice. I think that'll go a long way towards providing some coordination up front and minimizing disturbance, whether it's road projects and or our impact to companies making the moves. You know, again, our biggest concern is public safety. I think Rule 314E3B, we feel should address infrastructure necessary to support the proposed activity. Base and pavement failure, wheel rutting, dishing as it's called. You'll notice anytime a road gets wet, if it does have any impacts from heavy truck traffic, you'll notice the ponding in the wheel ruts, and that's an indication of base failure. And that's fairly common on a lot of our older roads that are impacted by heavy rig moves. And you know, those are things we look to work with the industry on to mitigate. So how we go about doing that is one of the key issues we've struggled with over time. Rule 314E10D, we think it would be beneficial if we could require some type of traffic impact study. We provided an exhibit, a sample of one study we had submitted, I think it was in 2013, with Swift Energy in their development of an oil well. And that put the burden on the industry instead of on county staff, and that worked out very well. But they look at the moves, the county shares information with them, such as our cost of maintenance on any given roads that might be impacted, our annual cost of maintenance, be it a paved road, be it a gravel road, and also the average daily traffic on that road. That gives them the tools they need to sort of analyze and evaluate the impacts of their added traffic, and helps us formulate a strategy to mitigate those impacts. And additionally, Rule 6031L, bridges. We had a bridge fail, I believe it was in 2004, it was in the southeast corner of the county. One of the local residents said there was some heavy traffic associated with a rig move that caused the bridge to fail. Fortunately, it wasn't a dead-end road. The residents had alternate routes in and out, which is beneficial and for emergency responders as well, but it caught us off guard. It was a load-restricted bridge, and it should have been assigned to the industry that, you know, that's a bridge you don't want to impact. But anyways, we've worked well with the industry, but we think there's room for improvement, and these are some suggestions we hope the commission considers.
Thank you. That's the end of our testimony, Mr. Chair.
Thank you to this panel for your testimony. I had a question for the panel, maybe for Commissioner Westendorf. The previous panel spoke to in the area of noise and I think, I forgot what the other one was, but changing a may to a will or a shall if the local government and the operator agree to a higher level. Did you have any thoughts about that?
So I unfortunately didn't have the opportunity to listen to that testimony completely. I was leaving in another meeting. I would say that our comments with respect to, I don't know exactly which rule they were speaking to. We do request under 423 that as it relates to consultation with local governments, that will be changed, excuse me, that may be changed to will. I will defer to Mr. Iatridis in the event that I believe he heard the prior testimony. If I've answered incorrectly, I'll ask him to clarify.
Thank you, Commissioner. Mr. Iatridis, did you have a comment on behalf of your clients about that suggestion from the Western and Rural Local Government Coalition?
Yeah, my thought is that there are potentially many factors at play, and there are other interests, such as, for example, a surface owner. And it's probably better if you retain some discretion that could take into consideration some other factors that might pop up, you know, and if it's pretty straightforward, then you approve it. Those are my thoughts.
Thank you. If I could, one other question, and then we'll turn to the rest of the commissioners. Mr. Davis, thank you for your testimony. It's always good to hear from you. Did you have a particular ask relevant to the rules that are before us on behalf of La Plata County and your coalition? I may have missed it if there was. I appreciate the testimony around impacts to roads and et cetera.
Well, I guess the specific ask would be that there is possibly strengthen Rule 314E3B, and that some requirement to address the impacts to infrastructure, that being roads, specifically those heavy rig moves, can in some cases exceed the capacity of a road and cause extreme damage and failure to road surfaces. And then I think it's Rule 314E10D, possibly consideration of a traffic impact
study. Okay.
Putting the burden on the industry. Otherwise, it puts a pretty significant burden on county staff trying to evaluate, you know, what roads are going to be impacted by this new well, whatever the facility is. And, you know, what is the cost going to be to the county, or what would the cost be for them to mitigate their impacts, which is typically, we don't like to see the taxpayers burdened by these impacts. We've got enough on our plate without adding that to it, and making a requirement whereby the industry evaluates their impacts, public safety issues, and they look at the mitigation and they propose mitigation to address those issues, would go a long way towards, I think, alleviate some of the impact to staff on these rig moves.
Thank you, Mr. Davis. One last comment, and this is directed to staff, and maybe if you could be prepared in closing, but the comment by Ms. Paget about existing facilities and you know, how these rules that we've created play into sort of upping the game around existing facilities. I'd like to have some discussion with staff about that. And then I'd like to have some discussion with staff about, to the extent the rules up the game around existing facilities, you know, how do we involve local governments around that? I don't need it answered right now, but I just wanted to acknowledge the good point made by Ms. Paget, and I think that is something that we should discuss, you know, perhaps at closing. So if staff could be ready to sort of have a discussion around that point this afternoon, that would be great. Other questions for this panel? Commissioner Messner and then Commissioner Nanjapa.
Thank you, Mr. Chair. And thank you all for the testimony. I thought it was well done. I wanted to follow up on a couple of things. So, Mr. Davis, I completely understand your point of view as far as impacts to roads and traffic and the need to address those, and for that burden to be on the operator. As a Gunnison County Commissioner, we had regulations that certainly addressed those within our local regulations. My question to you is, I guess, how much of that information do you want to see happen in your local regulations versus how much of that needs to occur at the state level?
Well, that's a good question. With the infill applications, I think the county has done a very good job with the MOUs when we have the opportunity to do so. And I think in part that's what's allowed us to do a better job of mitigating it. But, we've talked about the ability to come up with an impact fee program that might help streamline that process as well, but they're somewhat specialized and focused mainly on heavy industry traffic. But the thought is if there is a way to streamline this process across the board, not just on infill applications, but on every heavy rig move that has a potential to impact things. And a traffic impact study can be fairly simple, as the case has been on a couple that we've completed here. But again, anything we can do to minimize the burden. A lot of us are shorthanded these days with the decline in the economy and just hard pressed to find the time and the capacity to do the analysis necessary to determine and mitigate the impacts from the industry. So again, anything that can be done to help ensure that the industry addresses these and mitigates these or proposes reasonable mitigation. Staff is never going to be divorced completely from the process, but anything we can do that helps streamline that process would be appreciated.
Commissioner Messner, follow-up?
I don't have a follow-up on that. I have other questions, if that's okay.
Please.
Mr. Robbins, is it okay if I were to comment in response to Mr. Messner's question, just briefly?
Sure. Go ahead. Commissioner Weston.
I guess Mr. Davis spoke as to La Plata County's situation, and I'm also, we're a fairly sophisticated county. We have resources, and we've been doing this for a long time. I could see some of the things he spoke about being things that counties with less experience in this could benefit from a statewide rule. And while I wear a La Plata County hat most of the time, I've certainly had enough interaction with commissioners across the state to know not everyone is as technically sophisticated in oil and gas as our county.
Thank you for that comment, Commissioner. Commissioner Messner.
Thank you. So actually, Commissioner Westendorf, this is a question for you, and you don't feel like you need to answer it now because I'll certainly go back and reread the pre-hearing statements for the sections that you indicated. But I am curious because both you and Ms. Paget indicated the need to ensure visual resource protections, both for minimizing impacts perhaps to surrounding uses, but also to minimize impacts to the outdoor recreation economy or for scenic values, and I do appreciate that. Do you want to elaborate any more now on that, or do you want me just to go back and read that, the recommendations that you have?
I can elaborate. This is in conformance with our pre-hearing statement, but we would like to see that there be rules that encourage practices to reduce the contrast of those facilities and improvements with existing surrounding landscapes. That may be mitigation with structures, vegetation, wetlands, and also compatibility with existing structures, vegetation, wetlands, soil, geology, etc. There's a list attached of existing guidelines that are recommended, and that I would just suggest that the commissioners look at that. In La Plata County, frankly, we have a lot of our development is in a a juniper pinon sagebrush environment. And so a lot of our facilities actually look like they're deployed to Desert Storm. They're kind of camoed in olive green and tan, but it makes a big difference in the noticeability of those facilities. And I think it's very beneficial to the sometimes scenic values are considered less valuable. I think it's helpful for residents, and Ms. Paget talked specifically about a tourism economy, but having things blend in just works better for everyone, I think.
Is it appropriate to add a few thoughts on that point as well?
Yes,
I'd be interested, yeah.
Yeah, I just wanted to say that a lot of entities aren't necessarily aware of the really good strategies that have been proven that are in the La Plata County's document, but it's a model, whether it's for oil or gas or residential development. And the strategies that are in there are simply things like orienting the long axis and the short axis of a facility differently, which doesn't actually add any cost in most cases. And so, and folks, when they think about it, and they've never thought about it, these visual resource protection strategies before, say, oh, I would have done this if I had just known. I just didn't know. So it's really an awareness issue, and it creates what I call a social license for oil and gas and other types of contrasty facilities or improvements. When the cultural license happens, then there's just less conflict in the community between the values of the community and whatever economic or commercial or industrial activity is taking place. So I just want to encourage that this doesn't have to cost operators any additional burden or money in most cases. It's really a best practice.
Commissioner Messner.
Thank you for that. I appreciate that. And I think my last point and question is, I certainly concur with Chairman Robbins about wanting to go further into some of the comments that you made, Ms. Paget, and how we look at existing, well, both Commissioner Westendorf and Ms. Paget, but how we look at existing facilities and how we look at consultation with CPW through the lifetime of actions at those facilities, and how that interplays with consultation with the local government. And so I do think those are good points to bring up. You continue to bring up CNHP though, and I'm not familiar, I guess, with CNHP and exactly what the benefit or advantage of that consultation may be. So I wonder if you could elaborate on that a little bit.
Thank you, Commissioner Messner. I really appreciate that question. The Colorado Natural Heritage Program is based or embedded out of Colorado State University, and it's an agency that I personally and professionally have relied on. Also, county government and planning departments rely on it. What they do is they look at rare and imperiled species that might be on the state sensitive species list, the BLMs, the Forest Service, and they keep an eye on things that have high biodiversity or special characteristics that are vulnerable to development or activities or perhaps just climate change. And they have rankings of the how imperiled these species or biodiversity communities are. They develop reports in all counties across Colorado and identify areas they call potential conservation areas. And a lot of times those potential conservation areas end up getting nominated when appropriate for the Bureau of Land Management to become ACECs, or areas of critical environmental concern, which I'm sure you're probably familiar with. So the CNHP is being brought up because I did sense there was confusion or not so much awareness about it. But they look at things like our biological soil crusts, our special soils, and in San Miguel County, where there's oil and gas wells, there's a gypsum valley cat-eye, which is a rare plant. There's also some rare amphibians besides rare plants, and those are things that Colorado Parks and Wildlife, which has a different mission that emphasizes more some of the big game type species, just isn't it's a different mission, I guess I should say. So they complement each other. One of those two entities does not cover all of the important things to protect the environment, wildlife, and biological resources. You really need both.
Commissioner Messner.
No, that's it. Thank you very much.
Commissioner Nanjapa, I believe you were next.
Thank you, Mr. Chair, and thank you for your comments and testimony. And Ms. Paget, I just wanted to particularly acknowledge the comments related to CNHP and your thoughts that you just mentioned there in response to Commissioner Messner's question. And then I just personally will just appreciate the attention to amphibians, because that's a species, a group of species close to my heart. But I did want to, I just wanted to clarify, and this is maybe a little bit more for the staff, and perhaps could comment on how this has happened previously, but in relation to the current rules, or once they are adopted, my understanding is that subsequent operations on existing wells would be subject to the current rules, as I understand it. And so I just wanted to get that clarification. But I was just also looking through, based on Ms. Paget's testimony, where we have the notice or consultation with CPW or potentially other entities related to wildlife issues. And again, I think my understanding is that that would occur more in what's covered in the 300 series with permitting, but then just wanting to also touch on this issue about, as operations are about to commence, and the issues around notice that Ms. Paget had mentioned with respect to numbers of days and in advance of that specific operation about to commence. So it's a little bit, that's kind of a lot of stuff right there, but if there could be some comments on sort of how that works, that would be appreciated. Thank you.
Chair, I think AAG Minor might be best poised to hit this at a high level, and then I would acknowledge that we want to take a little bit of time in staff's closing to walk through some of the intricacies of the questions that we've heard over the last 2 days on the question of subsequent operations notice, local engagement in particular. So we might hit it at a high level now, and then stay tuned, we'll be back.
AAG Minor, we're looking for a high swing here.
Certainly, there are quite a few components to Commissioner Nanjapo's question, so I will attempt to answer those, but if I leave any out, please feel free to ask me a follow-up question, and as Director Murphy mentioned, staff can cover this in our closing presentation as well. In terms of notice of subsequent operations, there are a lot of different provisions in the rules that cover that. So if you look at Rule 405, that's sort of the Form 42 notice of things happening at an existing location, and that has subparts A through R, each of which is sort of a different category of things that can happen at a location, but largely at the suggestion of La Plata and San Miguel County. Staff carefully reviewed those rules, as Mr. Leonard mentioned, changed some of the timeframes to ensure that there aren't issues with local governments getting notice over weekends when they're not able to respond, and made sure that the relevant and proximate local government received notice of several categories of those activities that involve surface impacts. Staff did not propose adding local government notice to certain categories of subsurface impacts, such as remedial cementing, since that is more within the Commission's jurisdiction. And during closing, I can run through maybe each of those categories where the relevant local government does receive notice of that subsequent operation. Additionally, staff has proposed in this current August 17th draft, again, I believe at the suggestion of La Plata and San Miguel counties, adding local governments to the surface owner notification in Rule 412A, which means that the relevant local government will now get the same notice that the surface owner does whenever operations are occurring with heavy equipment on a location, I believe 7 days in advance of that operation. And then in terms of the substantive standards that apply aside from the notice to subsequent operations, staff have proposed Rule 312 that Mr. Andrews told you about during the 300 series. So that is a new rule governing subsequent operations that ensures that staff receives notice of all of those subsequent operations through a Form 4 report, and then provides staff the opportunity to add any necessary conditions of approval to protect public health, safety, welfare, the environment, and wildlife resources in the course of reviewing that proposed subsequent operation. And that would cover essentially any major use of equipment at a site that's not just very routine maintenance, like checking a tank valve or something, but certainly anything that would involve a rig. And then last but certainly not least, staff has proposed adding language in Rule 435A, subparts 1 and 2, that requires a similar review on a Form 6 submission for plugging and abandonment. So that's another category of operations at an existing site when that site is at the end of its life cycle to make sure that there is a staff review and opportunity to add any necessary conditions of approval to protect public health, safety, welfare, the environment, and wildlife resources. So that again is a high-level overview, and staff can certainly cover more detail during closing, but if there are any follow-up questions, I'm happy to try to answer them.
Thank you, Mr. Miner. Appreciate that high-level review. We'll look forward to further discussion. Are there other questions for this panel from commissioners? All right, seeing none, thank you very much. We have appreciated your participation in the work product that we're working on. It's very helpful to bring in the Southwest Colorado perspective. We will Zoom you away, and I think at this point we are due for our first morning break. So it is 11:16. Let's return at 11:30 and give us about a little bit more than 10 minutes. To the Colorado Oil and Gas Conservation Commission rulemaking. We're back from our initial break in the morning. I believe we have 3 additional parties before a contemplated lunch break. With that, Ms. Larson, do we have Weld, Air, and Water, Wall of Women, Margie and Lowell Lewis? Are they next?
Hello, can everyone hear me okay?
Yes, we can hear you.
Great.
Are you presenting on your own?
Yes, just me today.
Great. Introduce yourself and the floor is yours.
Great, thank you very much, Chair Robbins, commissioners, and staff. My name is Sarah Matsumoto. I'm an attorney in the Environmental Law Clinic at the University of Denver. Here on behalf of Weld, Air, and Water, Wall of Women, and Lowell and Margie Lewis. As you know, these are community groups and individuals in Weld County who've been impacted by oil and gas development. My clients and I understand the task before you is large and challenging, and really appreciate your work, your steadfast attention to community feedback, and just all the time that's gone into the process. I want to briefly address a couple areas in the August 17th draft. First is lighting. I know there's been some discussion of safeguards around lighting today, and was glad to see the latest draft included some additional limitations and safeguards concerning maximum lumen levels in Rule 424D. A couple suggestions here would be that if a light mitigation plan is going to allow a higher maximum permissible light level, that there be some type of notification to the community. Additionally, considering some type of durational limit that's similar to what exists concerning noise for lighting would help to minimize disruptions to folks living nearby. And the additional limitations for certain types of areas, or areas zoned for certain uses, I think are helpful, but temporal limits might help as well, especially in those areas where lighting might be quite intense. The second issue just is around complaint processes. Community members want to know that their concerns will be taken seriously and responded to in a timely manner. Rule 426D outlines kind of a specific complaint process for odors. Certainly that's really important, as odors can signify heightened health risks. We suggest that the 400 series overall include perhaps a more comprehensive complaint process that would apply to many of the other areas of concern as well. So one possible change would be to include a time certain by which someone needs to physically arrive at the location that's the source of the complaint in order to investigate. This stems from, what is perhaps not surprising to any of you. Sometimes a community member might submit a complaint and quite a long time passes before the complaint is actually investigated on the ground, at which point, if it's been days or even weeks, the problem that was giving rise to the complaint may have subsided on its own. And so then it leads to this, or contributes to this feeling that concerns are just perhaps not taken seriously or not fundamentally solved. So another potential change for the 400 series rules would be to examine how this series works together with the director's discretion in the 900 series, and include some type of language or automatic trigger for the reasonable cause standard that's based on receipt of either a certain number of complaints or complaints in a certain amount of time. You know, and I understand this is a delicate balance because certainly we want the director to have discretion to exercise, you know, what is reasonable cause, and there may not be a hard and fast definition that is used in every circumstance. But this is one way that you could ensure that community complaints are really taken seriously and responded to quickly. The last area that I wanted to touch on, first is groundwater monitoring. I appreciate the additional language around publication of monitoring data. I would encourage you to consider adding language in the rules or perhaps adopting internal guidance that any groundwater monitoring data be made publicly available or just included in the permit file so it can be publicly accessed. And then lastly, I really appreciated the testimony of the panel before me about the importance of visual resources. Many people, like my clients and others, really value the visual beauty of areas like Weld County and other rural areas in our state. The presence of trees and vegetation and wildlife contributes to their quality of life and enjoyment. And so I'm very supportive of some additional rules that could help to ensure visual resources are protected, and also would encourage you to consider looking more into consultation with CNHP. Thank you very much. I'm happy to take your questions.
I'm muted. Thank you very much for your testimony. We appreciate your representation of the community groups. Do we have questions for this witness? Commissioner McGowan.
Mr. Chair, I think I'm struggling a little bit with your recommendations around noise. I understand what you're saying, but I also believe that there are maybe some physical limitations to, for example, getting an inspector out timely, and how that might work. And then kind of the burden of proof. If the burden of proof was, for example, number of people who called, I think that there's a danger that could be potentially abused. And so I'm wondering what your thoughts are about that. I get what you're saying, but implementing that, I think, to me, feels a little rather difficult.
Sure, and I agree with you, and I understand that obviously, we don't want to risk some circumstance in which there's an abuse of the complaint procedure, and then either agency staff or operator staff have to spend their time to responding to things that aren't necessarily serious. I would think one way potentially to address this would be kind of looking at different tiers. And so, there might be one streamlined complaint procedure, something like odors. Perhaps somebody would be present on site or be required to be present on site to follow up a little more quickly than something like lighting, which may not kind of signify as urgent of a potential health exposure or health risk. That might be one way to consider doing it. I'm not sure that I have the exact timeframes or the expertise to consider what those are, but one streamlined process with different kind of tiers of time, depending on what the issue of concern is, might be one way to do that. Certainly, I understand, and I don't think I think by and large, many community members wouldn't want to abuse that process, because then that creates perhaps an unwillingness or a reluctance on the part of the investigator to take things seriously and respond to things timely as well. So I think and hope many people would be sincere and take it seriously and try to reserve those instances for when it's truly an issue, rather than just trying to abuse someone's time or abuse the ability to issue a complaint.
Feedback.
Other questions for this witness? All right, seeing none, thank you again for your participation and your testimony this morning. We appreciate it. We will disempanel you, and we will bring the next panel on board, which is the Wildlife and Biological Resource Coalition, for a anticipated 6-minute presentation. Good morning, Mr. Tropoulos.
Good morning, Mr. Robbins and the commission. Let me try and share my screen. Okay, we're ready to roll. Mike Chiropoulos for the Wildlife and Biological Resources Committee. And we'll try and get that full screen. There we go. First, I want to make a quick comment on our pre-hearing statement regarding the sundries and post-drilling operations that Mr. Bovey's testimony covered 2 days ago. We want to make sure that our request was heard, and it's in our pre-hearing statement at pages 2 to 3. We want the opportunity for public notice and comment on post-drilling operations, including refracking, re-drilling, and significant ancillary infrastructure, anything with a potential for significant impacts to priority habitat. And I'm not sure that the discussion we heard yesterday captured what we're asking for there, and I'm raising a question whether some operations that we're concerned about might not be directly tiered to the original 2A. So we want to make sure those are covered. For today, Ms. Hackos is going to be our witness, and the overview of what we're talking about on noise and light. Our first set, wildlife and biological resources, are adversely impacted statewide. Siting is the best way to avoid impacts. Next, minimizing and mitigating at both new and existing sites, informed by science, engineering, experts, local government successes, and collaborative efforts as you're hearing today. Noise impacts are recognized in the State Wildlife Action Plan and the corridors report, as we stated in our response brief. On 423 and 424, we're calling for best practices across the board, the highest protective standards for priority habitat to minimize impacts, a rebuttable presumption standard that highest standards will apply, statewide protections, working and learning together, and all in the context of a comprehensive rules framework applying to the entire life cycle of oil and gas operations. I included a definition of rebuttable presumption because that's what we're proposing in our rule. And my last bullet before Joanne goes is that noise and light impacts to wildlife and biological resources are real, and we want to be part of the solution. Joanne, you're up. Do we have Joanne?
Mike, you need to
there we go.
Unshare your screen.
There.
Thanks. Okay, now I can share mine. Nope, not yet.
Yep. We'll turn the timer off while we get the screens shared correctly.
Okay. Is that working now?
That is working.
Okay. And there you go. I'm Joanne Hackus. I'm representing Wildlife and Biological Resources Coalition, the 25,000 member Audubon, Colorado Council, and Evergreen Audubon. I'm here to voice our belief that light and noise mitigation must adequately protect wildlife and biological resources, especially those occupying sensitive and high priority habitat. Recognize that since 1970, we've lost nearly 3 billion birds from North America. In fact, the most impacted are Colorado's grassland birds, which are 74% of which are in decline, with a 53% current reduction in their population. Migratory birds face an ever-growing ecological threat, as do all nocturnally active animals. Birds migrate at night. Artificial light at night endangers them. They fly into structures that are excessively illuminated and they die. They circle bright light sources until they collapse and die. Bees and other nocturnal pollinators are also declining worldwide. Most recent estimates of we've lost 93% of our western bumblebees. Not long ago, they were the most populous birds in the country. Today, they're fighting for their survival. night foraging creatures like owls and bats can't hunt under bright lights. They move to areas already occupied by others, competing for natural resources. This photo was taken 1 mile away from an active bald eagle nest and communal roost along Boulder Creek in Weld County. Notice that there is no light or sound mitigation going on. And the glare from this operation continues even in early morning hours. About a mile away from this photo where it was taken. Most affected from oil and gas drilling production and continuing workovers are birds that once were common in Colorado on the shortgrass prairies of the eastern plains and the sagebrush steppe of the interior valleys, including our iconic western meadowlark. There's an urgent need for noise mitigation, especially quieting compressor stations in oil and gas fields. A 2011 study in Ecology Letters found that sustained exposure to noise and oil and gas noise impacts can affect neuroendocrine systems, reproductive systems, cardiovascular systems, and metabolisms from sustained exposure to noise. A 2017 study in the fields of New Mexico, oil and gas fields, demonstrated and other birds and wildlife. Natural acoustic conditions should be a key aspect of conservation planning and is our critical step towards successful conservation of protected species. A COGCC Commission study in 2017 showed that oil and gas sources regularly exceeded maximum permissible noise. The highest WBRC strongly recommends that the Commission maintain the strongest statewide noise and lighting protections for wildlife and biological resources. We need to apply the highest standards, protective standards for high priority and sensitive habitat, where noise and lighting adversely impact the resident and migratory birds and other wildlife and biological resources. We support the position, by the way, of the Allied Government Coalition to create a task force on complex issues of light and noise pollution. Note in this satellite from NASA that the Western oil fields are almost as bright today as cities like Chicago and New York, with light produced by well pads, storage sites, and flaring of natural gas. The introduction of artificial light probably represents the most drastic change human beings have made to the environment for nocturnal animals. Human-made noise is a pervasive pollutant that decreases environmental quality. It disrupts a suite of behaviors vital to perception and communication, and it alters the habitats, degrades natural acoustic conditions, and displaces our sensitive species. Thank you very much. I'm happy to take questions.
Thank you, Ms. Hakos, and thank you, Mr. Teropoulos. Ms. Hakos, if you could stop sharing your screen, that would be, thank you very much. You're already going there. Do we have questions for this panel? Mr. Teropoulos or Ms. Hakos, maybe I'll just ask this to either of you. But you know, I heard your testimony, obviously, and find it significant. But I didn't hear sort of, you know, you talked about best and the most and the highest. We have before us drafts from staff that have noise and light standards. Do you have an opinion that those don't go far enough, that we need to be more? I mean, I guess I'm looking for a little more particularized testimony.
Right.
I think we. Go ahead, Aaron. Go ahead.
Yeah. Hi. Thanks, Mike. I think that the issues we see is that, particularly for light pollution, that the measurements in our lumens are not adequate, and need to be corrected by data from the scientists on how we measure light, how far away we measure light, what is the cumulative impact of multiple light sources, and that we need to measure those in with the values of lux rather than lumens to make sure that we're measuring things that affect the environment. We think that, as you've heard in other testimony, that the noise issues need to be mitigated more effectively and include the wildlife areas in the areas that are being supported, especially sensitive and high priority areas. I'll note that the current regulations only talk about state wildlife parks and don't include high impact, high priority areas and otherwise sensitive areas. So we think that there needs to be refinement of the measurements, the numbers in the measurements, and all of those in consultation with scientists in the field who can provide the best numerical values to use. I'm not one of those scientists, but I've been reading their reports and speaking with them, and they're telling us that the numbers in the current rules are just not adequate.
A quick follow-up. I can't speak to the technical side and the lumens, but the direct proposal we made for both 423 and 424, and I've got it on another screen here, 423B1 provides, it's got layers of protection based on the area category in the rule. And currently the highest protections, the top category is for quote residential/rural /state parks and state wildlife areas. We specifically propose that priority habitat be added to that highest protective category. We've got something like Mr. Bovey's bald eagles, the pollinators that Ms. Hackos talked about, and a rebuttable presumption. So if the habitat, the priority habitat that's protected by the rule isn't necessarily affected by either the noise or the light, perhaps the highest standard wouldn't be necessary, but a rebuttable presumption for staff and other parties to look at.
Thank you, Mr. Charopoulos and Ms. Hackos, for that additional testimony. Do we have other questions for this panel?
Mr. Chair.
Nanjapa?
Thank you, Mr. Chair, and thank you both for your comments and testimony. And I appreciate the clarification that you just made there with respect to the highest possible standards. One thing I noticed in your pre-hearing statement was the reference to the March version of the draft rules with respect to, I believe that was for noise. And I guess actually maybe this is more of a question for staff, but I was just curious as to what ended up changing that with respect to the specific commentary on the impacts of noise. Though I will also note that I see that there's some additional language with respect to consulting with CPW or adopting higher standards upon their recommendations. So if you could just kind of walk through that a little bit, or perhaps if it's more appropriate, we could save that for closing comments.
Mr. Chair, if I may.
Yeah, Mr. Minor.
Certainly. So I apologize if I don't remember exactly how the wording has changed from the March draft to the August draft, but I would direct you to Rule 424B4, Commissioner Nanjapa, and that is where the noise standards for high priority habitat are set. The reason that staff intends to consult with CPW or where appropriate the Bureau of Land Management or the U.S. Fish and Wildlife Service on a case-by-case basis for those standards really gets to some of those scientific studies that Ms. Hackos was mentioning. And that is because different wildlife are impacted differently by noise. And so it's actually uniquely challenging to identify appropriate noise levels on a sort of statewide basis for all wildlife. And it's really important to have that consultation because different species have sort of different thresholds at which they're impacted and perhaps aren't impacted. And because of that, it's really important to weigh sort of all of the impacts so there can be, and I apologize, Dr. Denise Arthur, who's the reclamation supervisor is really much more of an expert in this. She's the one who reviewed all the peer-reviewed science. But essentially, there's a risk of altering the predator-prey relationships unintentionally by setting a standard that is protective of one species, but like might not impact another. And so it's sort of achieving that delicate balance of ensuring that there isn't an unintended consequence of accidentally picking some winner and loser species meant that staff felt that it was more appropriate to do that case-by-case consultation rather than setting a single standard for high priority habitat in every case.
Mr. Tropoulos, would you like to comment on Mr. Minor's analysis?
Yeah, real quick, and appreciate it from Mr. Minor. And the thing I'd like to add is we very much respect CPW's role and expertise and entirely support it. And just like you're hearing from the local governments that they want to be heard from, and especially San Miguel really caught my attention talking about the Colorado Natural Heritage Program today. And I was learning as she spoke. We want to make sure that for these noise and light and dust nuisance issues that the commission and staff are willing and able to hear from the public, which might have some expertise about these site-specific wildlife and biological resources issues. And I think just listening to the witnesses we've presented to date, these folks really know their stuff. And they know these issues in Colorado. And I think everyone will benefit, including the operators, who I think share our desire to avoid, minimize, and mitigate impacts from these sources.
I think it's important, like, if I can add a point, to be aware that these wildlife, migrating birds, resident birds, are present throughout the state, not just on the Front Range. And we need to recognize that there are living creatures in those environments who are severely impacted, not just people and local residents.
Thank you, Ms. Hakos. Do we have further questions for this panel? Looking closely, I don't think I'm seeing anybody. Thank you very much. We appreciate your involvement and presentation to us this morning.
Thank you.
At this time, we will dismiss this panel and bring to the House the Small Operator Society. All right, I see Mr. Moore, Ms. Blanchard.
Thank you, Chairman Robbins, and good morning, Commissioners and Director Murphy. I'm Jason Moore on behalf of the Small Operator Society. I'd like to start by saying that, like others, we generally support the 400 series rules, and we thank staff for their efforts to build consensus. In fact, we only have a few remaining issues that we'd like to discuss today. So I'm now going to turn it over to Amanda Blanchard with SG Interests, a member of our small operator group. Amanda will discuss the preset conductor provisions in Rule 406, the public water system provisions in Rule 411, and the noise provisions in Rule 423. So with that, over to you, Amanda.
Thanks, Jason. Let me share my screen. Hello, Commissioners. Thank you for the opportunity to provide testimony and for your careful consideration of my comments. My name is Amanda Blanchard, and first and foremost, I am a mother and an environmental professional. I own and operate a very successful fly fishing business that relies on a clean environment and responsible environmental stewardship. Protection of public health, safety, the environment, and wildlife resources is the utmost importance for me and my family. For 12 years, I worked as a biologist, evaluating the impacts to natural resources and wildlife under the National Environmental Policy Act, NEPA, for proposed energy projects including wind, solar, coal, oil and gas, transmission, and geothermal. Now, as an environmental and regulatory manager at SG Interests, I've applied both my regulatory and biology expertise to existing and proposed oil and gas development. I've applied my master's education in sustainable multiple use management to help my company meet the needs of Colorado citizens' energy demands while also protecting wildlife and other natural resources. My testimony today is on behalf of SOS and its over 62 small oil and gas operators. We are in general agreement with the 400 draft rules. However, my testimony today focuses on several recommended changes and clarity to the rule language That will make people in my current position able to ensure regulatory compliance. My other concerns discussed in my written testimony have been addressed and are workable. Starting with draft rule 406E4, it was modified to require plugging and reclamation of a conductor if the well was not drilled within 3 months of setting the conductor on cropland or within 6 months of setting it on rangeland. And the statement of basis and purpose ignores the benefits of preset conductors and suggests seeking a variance request when going to hearing to extend this time frame doesn't seem reasonable. There are no impacts to public health, safety, environment, or wildlife resources from preset conductors. As you'll see in this picture, it shows the well cellar, the conductor pipe, which is the outermost casing of the well, to stabilize the well for drilling. It's usually 20 inches. It has a welded cover. It has a safety gate. It has even a wildlife safety ramp so mice can successfully get out. SOS requests to extend the time for plugging a conductor to a Form 2 or 2A expiration, or at a minimum of 12 months. The risks are shorter, or the risks of a shorter duration are actually greater than a longer duration. You will see increased traffic and increased disturbance, double the expense with a shorter duration if we need to plug and reclaim that, not to mention the concerns by surface owner due to increased activity on their property. The benefits of preset conductors: they are a stabilization tool, they are protection from minor ground shifts around the well. We use small rigs or even just construction equipment, which reduces the duration of drilling of a larger rig when we go back in. And we often set these preset conductors prior to wildlife timing stipulations. So for example, before a wintering big game area. And then some real world factors that we must consider is, again, the wildlife timing stipulations, private land hunting and agriculture timing restrictions. Winter weather and poor road conditions also reduce the available days in a given year to drill a well. And then commodity prices. We cannot control commodity prices, but we do control the development of capital, and it would be wasteful for operators to prematurely plug these conductors when there is an intent to drill them. We appreciate, moving on to 411, we appreciate the efforts by public water supplies and industry and staff to work through these new requirements, and we believe that there is substantial consensus on Rule 411. SOS does concur with the support the notice of consultation and a waiver process. However, we do understand that the Public Water Supply Group after lunch may propose a no surface occupancy buffer zone setback for a new category of recharge areas. Given the late nature of this proposal, we have not had a chance to review and evaluate this potential impact, and we have many questions about the proposal. We do not know where these recharge areas are or how they should be defined, as they are overly broad, not overly broad. Rather than imposing setbacks for recharge areas in the 11th hour with no stakeholder engagement, it is more appropriate to simply require consultation with public water supply. In response to the discussion yesterday on ephemeral streams, I found the following both in the draft COGCC draft 200 to 600 statement of basis and purpose and the Reg 31 Water Quality Control Commission statement of basis and purpose. In essence, the very definition of ephemeral streams means that there is a lack of connection to groundwater. We support staff on the statement of basis and purpose. Moving on to 423, noise and lighting. SOS members support prior industry testimony that the Commission should refrain from requiring noise or lighting plans in remote and rural areas and should not set the maximum noise decibel or luminance thresholds for rural areas where operations may be miles away from residences and as in residential areas. Rural and agriculture should remain the same. There are operations in agriculture and rural areas. We agree with the other industry testimony, as I said, but to add a little more color, some of the larger operations require more traffic, more equipment, more people. This is increasing sound and increasing lighting needs. We travel up to 10 miles to even get to one of our locations or to even find a residence. A blanket approach just doesn't make sense in all situations. There are very few situations in remote areas where lighting and noise are a significant concern. And they are very short term with that as well, not lasting more than a few weeks, if that. In addition, we don't hydraulically fracture all of our wells. We don't require multiple acre locations where heavy construction is occurring for weeks on end. Many of our locations don't require equipment with massive horsepower. We have seasonal wildlife restrictions limiting on daylight activities, weather restrictions. So noise and lighting impacts from these activities are further reduced in comparison to operations that don't have these restrictions. The 15-minute increase once in a 12 period in the August 17th draft was an improvement, but it lacks clarity. Are we supposed to have a stopwatch every time a piece of equipment backs up with a 90 decibel horsepower or decibel? This addition needs to be extended. We fully support Kinder Morgan's federal coordination testimony today, specifically the high priority habitat consultation, as well as Western and Rural Local Government Coalition. I removed my slides addressing agency coordination because they covered what I was going to. Thank you for working with industry and at least acknowledging our regulatory compliance concerns with some of the rules.
And with that, I think we'll open it up for question and reserve our remainder time for closing. Thank you.
Thank you, Small Operator Society, Mr. Moore and Ms. Blanchard. You're winning in terms of the presentation of the photos of the fly fishing, and very jealous there. Did you catch the fish in the first photo, or was that your daughter or some other child that caught the fish?
Oh, that's me. Oh, but that's a small one. That's on the Animus.
That's great. Anyway, I'll move on. I was gonna rabbit hole us about fly fishing in the Southwest Colorado, but I won't. All right, do we have questions for the Small Operator Society panel? Commissioner Gonzalez.
Thank you, Mr. Chair. Thank you, Ms. Blanchard, Mr. Moore. I've got a question about the photo you showed about the conductor being set and having the fencing, the little escape hatch and all that good stuff. And I'm curious how consistently that setup is applied on operations across the state.
In my experience, I can speak to it just in my experience, which it is very consistent. In addition, it is a requirement that we have to have wildlife escape routes and a safety grate. So I feel like it is consistent, but that's in my experience.
And, you know, in the statement of basis and purpose that the staff has kind of pointed out that inspectors on numerous occasions have come across trapped or deceased wildlife within, you know, within those conductor. And I was curious if you could, I don't know, is staff wrong about that? Is that not a problem?
No, you're absolutely correct. We have our SG Interest has specifically gotten a violation for trapped wildlife. And in all of those situations, they have been mice. And not to say that mice life are less important than other wildlife, but we do have lots of mouse traps set in our office. So those mice do end up getting caught eventually. Hate to say it, I guess. But we do not find any other mammals besides mice in those well cellars.
Thank you.
Other questions from commissioners for this panel? All right, thank you panel for your presentation. Again, appreciate the general support and appreciate the detailed proposed edits. For you and for everyone else that has detailed proposed edits, if you could email your slides to Ms. Larson, that helps us in deliberation. With that, I believe that we are at our lunch break, which was scheduled for 11:45. It's 12:08. We were scheduled for a 45-minute break, so if commissioners are comfortable with it, why don't we take the lunch break now and reconvene at let's say 1 o'clock, a little more than 45 minutes. All right. Thank you, everybody.